Happy Tuesday. It's time for coffee and Cursey words, and we are celebrating a very important national holiday. Today is National Pumpkin Spice Day. I don't know if it's a real thing. I've made it up, but today is the day that the Starbucks pumpkin spice menu comes out. I am excited. I am basic. I don't care. Last year, they introduced the pumpkin cream cold brew, and I was so sad when it was gone in the winter. I mean, I was sticking my hand out the window at the drive-thru in like 10-degree weather to get a pumpkin cream cold brew. I was very excited. I got myself an ultraviolet cup today. I'm ready for it. I'm ready for Tuesday. We have so much to talk about today that I needed the entire pumpkin cream cold brew. I mean, I might have gone to 5 other Starbucks to try to find the matte. So I have a matte black Starbucks, and we've got some Lawnard similar studded mugs coming, or cold cups coming, and that's a whole nother thing. But they have like a flamingo Barbie Elle Woods neon pink that like none of the Starbucks in the middle of Tennessee got. And so I wanted the matte pink. So I went looking for it. No, not all the Starbucks got the fall thing. I went to my reliable places. All of my reliable places, and they didn't have it. So let me know what you're drinking. It is so good to see all of you. We're going to just get into it. We've got quick bits with Tom Girardi getting disbarred and Scarlett Johansson. And then we've got 5 Duggar motions. 5 Duggar defense motions that are very interesting. And then we've got to go over the Tati restraining order, temporary restraining order, injunction motion. The transcript of the hearing is up, though the order is not officially up yet because the lawyers are arguing over the order, and we'll talk about that in a minute. So the Texas said, oh my God, I would love a Lawnard cup. Oh yes, we are in the studded variety. We are working on them. We have so much to come. So let's just get into it. It's so good to see you guys coming in. And Andrea, thank you for your NordVPN code. Just managed to get my new VPN and at an extra low price. Exciting. We love it when you guys love the sponsors. I mean, okay, look, YouTubers and content creators say this shit all the time. And I'm always like, but really though, but the amount of things I say no to because I'm like, I'm not telling the Lawnards to do that. That's not a right fit. Like the amount of stuff that gets said no to. And that's not like oh, poor me. That's just a no. I will only talk about things that I can stand behind because there's no point in just talking about anything, right? So I appreciate that you guys like it. It's so good to see you. Okay, we need to get going. We need to move. I'm going to just roll the intro so we can just get into it. Oh, replay crew. Love you the most. There will be timestamps down below so you can go see the shit the shit you want to see. You can go see the shit you want to see the most. All right, let me know where you're coming in from and what you're drinking this fine morning or evening, depending on what part of the world you are in.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
Oh no, Haley, your whole house has COVID. You, hubby, and 4 kids, even though we vaxxed, it's horrible. Everyone stay safe. Thanks for the distraction. Haley, take care of yourself and your family. I have heard plenty of people who have had breakthrough infections from getting vaxxed. I am sorry that you're experiencing it. We are definitely experiencing that here in Middle Tennessee too. Schools have been closed because people have been exposed and are quarantining. We're having busing issues because bus drivers are out. There's already a bus driver shortage, but bus drivers are out because bus drivers are quarantining. There you go. If you guys don't follow me on social media and want to keep up to what's going on in my life, when I talk about my life shit, that tends to be on the Instagram at the Emily D. Baker. The like news and kind of legal stuff, like the fast, like, hey, this just happened, is on Twitter. And then of course the live streams and like the deep dive content is always here. So if you just wait, go follow me on Instagram and just count the days. You guys can take a bet on how long it will be before I'm like, well, and the kids are not at school today, because there are little schools within our district that are closing because too many teachers are out quarantining. So yay, that's just happening. Back to school has been a rough one this year, but we're just going to keep going. We're just going to keep going. Welcome, Brazil. So good to see you guys. Slovakia and matcha latte, Ireland and coffee in sunny afternoon, cold and rainy. It is hot AF here in Middle Tennessee. It doesn't really feel like fall, but that's all right. 2 a.m. in Queensland, Australia. Susan, we will try to make it worth it, but I know you guys are all stuck at home. So I get it. Smoky Northern Nevada drinking cold brew. We're going to be talking about Nevada a lot later on for sure. All right, you guys, let's get into our quick bits. Oh, I'm going to say thank you for some of our super chats, and then we're getting into quick bits. It's 6 p.m. here. So while you are drinking coffee, I'm drinking rosé. I mean, I wish I was drinking rosé. Also, there's a special Halloween Starbucks mug in Taiwan, a black cow with orange witch's hat. I want it anyway. Allegedly, Angela, that sounds amazing. I want it too. That Taiwan gets the cutest stuff. So does Japan. And Korea too. They get definitely different stuff than we get here in the West, and some of it's really, really cute. HP Ford said, so love your channel, coming in from Marina in AZ, recovering from knee surgery. I've been there. It sucks. And of course, have to jump on here. So curious about this new BS with Josh. It's interesting. I mean, his defense attorneys are doing their job and doing their job. Public Health Gal, thank you so much for alerting us to pumpkin everything coming back to Starbucks. I went and got a pumpkin spice latte, and my fall loving heart is so happy. I know, it's like, look, the world is like so crazy right now. I'm ready to put on Ugg boots and flannel and be basic and pretend it's like, 2010 and just be like, la, 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 la. Like there's a little escapism needed, and somehow the pumpkin spice just warms my heart. I was listening to like Olivia Rodrigo and Taylor Swift in the car, and I was like, it's all gonna be fine. It's all gonna be fine. It's all gonna be fine. We're not stressed. It's all good. It's all good. We're all okay. I'm okay. You're okay. We're all okay. We're doing our best. It's just a lot. Any chance you'll cover the Friendly Jordies versus, I've not even heard of that. Barrio is arguing that Google is a publisher, so it can change the whole YouTube sphere. I haven't heard of it. Please go ahead and DM me on Twitter, and I'll add it to the list for sure. I've also been getting a lot of DMs about the Twitch lawsuit with the dude who I don't watch a lot of Twitch. Literally, I go onto Twitch and watch who do I watch on Twitch? Aphrodite, and that's about it. I don't understand Twitch. I'm also ADHD, so on Twitch there's a lot of like bells and whistles and things happening. I'm looking at Twitter. What is it? My podcast editor Dan was sending it to me. Irish Badass was sending it to me. What is the dude's name? Dr. Disrespect suing Twitch. So I'm going to be looking at that too because I'm curious. Thank you. Even when I'm feeling down, you always cheer me up, and I'm so intrigued to learn all about the legalese. We've got a lot of legal today. Ashley Vincent, good to see you. Thank you. Glad to see you here. Happy for you. All right. Yes, Dr. Disrespect. Yes. Lori, hello. Good to see you. Would love to hear your take on Disney Scarlett Johansson. Lori, I owe you messages because I forget to check Facebook all the time. Hi. And yes, I have a whole podcast episode about it, and we're going to be talking about it in just a minute. So Lori got me back on track, which, is not uncommon for Lori to get me back on track. So thank you. Let's get into our quick bits. First, we had over 1,200 votes on the poll about whether it was your, pumpkin spice happy place. And 40% of you said no, just no, it's August. 39% of you said yes, all the pumpkin, which I love. And not yet soon was 19% of you who were like, I'm going to get the pumpkin. But I see you, 39% of my peeps. I get it. Not everybody is ready. Not everybody's ready at all. So let's do quick bits. Quick bits. That's my quick bits intro. That's what we're doing. We do that now. That's what we're doing now. I don't even know. I don't know what to tell you. That's what comes to my mind when I think of the quick bits. I'm going to go ahead and share the screen, and we are going to talk about Tom Girardi getting disbarred. This was reported in People. We're going to go to their reporting. I mean, because we are. All right, let's pull this up. Hopefully it doesn't lag too bad. Some of these websites are really heavy with their ads. So this is from August 21st, 2021. Tom Girardi officially disbarred by California federal court. I'm going to explain what that means. And I've shared some of this on Twitter and on Instagram as well. So this is from Abigail Adams. Tom Girardi's brother, Robert, was designated as the former attorney's permanent conservator in June following his recent dementia diagnosis. Tom Girardi has been disbarred. According to documents filed under the Central District of California and obtained by People, Girardi did not contest the decision. Podcast host Emily D. Baker was the first to report. The 82-year-old's federal disbarment, which was handed down by a judge on Friday. A state disbarment is still pending, Baker reports. What did it say, chat? What did People say? People said first to report. First to report. Can we get that into a lawsuit? I was the first. The first. Can we just get it in? Can we put it, where else can we say, as I broke the story? What else can we do with that shade? Can we just enjoy it for just a moment? We're going to. On June 9th, Tom's younger brother, Robert Girardi, was designated as his permanent conservator. Court papers obtained by People in mid-July cited the former attorney's recent dementia diagnosis. At the time, Tom said he opposed the conservatorship altogether and suggested he would address his concerns. That has not happened yet. I think we should put together the reasons why the conservatorship should be dissolved, and we'll address the court. He said that to the court, which is concerning. So, yeah, this is an ongoing issue. It's also just recently been reported that he is moving into a assisted living facility. I'm sure he's prepping for the sale of the house in Pasadena, because once the house in Pasadena sells, he will have to be out anyway. So I'm going to pull up the court documents, and then maybe I'll just pull up one other article just for fun. Should we? Let me know. Should just put a yes in the chat if we should just pull up, or no, purple hearts in the chat if we should just pull up one other story, like one other story. So this is the official order of disbarment. I shared some of this on Twitter. On May 27, 2021, the court issued an order to show cause. This is the federal court in California, the order to show cause. They issued an order to show cause, why he should not be disbarred from this court being the federal court of California. So this court being the federal courts. There are federal courts and state courts. Generally, when you're admitted to practice in the state, you also seek admission into the federal court so you can practice in federal court. So this is a disbarment from the federal court. So he cannot go into federal court, but he's already suspended from the state court. So this is more of a formality or a hit to the ego than it is an actual practical anything more happening, because he is already suspended due to the conservatorship, and that's not likely to change. And the state bar will probably disbar him. They go on to say that as a result of his or her disbarment by the Supreme Court of California, resignation from the state bar with charges pending, or enrollment as an involuntary inactive member of the state bar with cases pending in this court. A written response was due 30 days from the date the order was issued. The court has received no response. It's therefore ordered that the attorney named above is hereby disbarred from the practice of law in this court, pursuant to Local Rule 83-3.2.1. An attorney disbarred on this order will be reinstated upon proof of his or her reinstatement as an active member in good standing with the state bar, which is not going to happen. I've been going through the state bar documents, and those will be not in this week's Emily show, but next week's Emily show, where the lawyers for his brother, who's his conservator, were like, we issued a resignation and we're not going to touch it again. So they tried to resign, but the resignation requires some admissions or a agreement to be disbarred, and he did not do that. So the state bar is like, yo, that's not how that works. So we will see what happens. I think the state bar disbarment will be coming in short order because he hasn't contested it. He hasn't responded. They had stayed it a little bit, and they just at the beginning of the month of August lifted that stay and are going to be proceeding forward. It looks like he will be disbarred because this was asked just in the chat from Michael. He's not being disbarred because of his mental state. He was suspended because of the conservatorship. He is being disbarred in the federal system based on all of the pending cases, and he will be disbarred due to the charges against him. I linked the video on Twitter, but I will link it here. I have a video going over the suit essentially from the state bar, making a lot of allegations about money being missing, and those have now been found to be true. So it's not even alleged as to the charges from the state bar. Those were just found to be true. So let's just do one more. Why? Because we can. ET Online picked up the reporting from People. Tom Girardi disbarred by California federal court amid health problems and legal scandals. No video ads. Shush, tab. The ruling has been made. Tom Girardi can no longer practice law in California federal courts. The embattled attorney and estranged husband of Erica Jane has been disbarred by the California court. A source tells ET that Girardi is no longer, quote, allowed to practice in the Central District of California for the federal courts, but that the state bar proceedings are still pending. It's any federal court, really. The ruling was handed down on August 20th, and Girardi reportedly did not contest the decision, according to People. Emily D. Baker, host of the Entertainment Law Podcast. I really think that's what we are, too. I think ET accurately summed it up, that we are an entertainment law podcast over on The Emily Show, was the first to report the 82-year-old's federal disbarment. Why, thank you, ET. I appreciate you. And then they break down kind of what led up to here. So we're just gonna say it just for a minute. No, it's just, I saw it come down. I got the court alert on Friday while I was live. So when I was going through my court alerts on Saturday, I was like, oh shit, that happened. So that's in the federal system. The state system will disbar him. It's just a matter of time. So the disbarment is not really actionable or practical, if you will, because he's already suspended from the practice of law in the state of California. With everything going on and the amount of cases in the bankruptcy and the fact that he's 82 and in a conservatorship, it's not like he's going to practice anyway. But it's a hit. Like, it's a hit. Being disbarred is a hit to the legacy, and it's something these articles will be permanently attached to his name. This part of his legacy will be permanently attached to his name, though I don't think the disbarment is the most embarrassing part of all of this, right? I mean, I think the allegations, and some of them are now proven, like the state bar claims of money missing from client trust accounts, the Ruy Gomez case where they were ordered to be paid their settlement fees and weren't. I think those things will be more of a mar to his legacy than others. He's already been stripped of a lot of the words that he's been awarded. So that legacy is definitely crumbling. The disbarment is kind of just, I don't know, formalities on top of it, really. Let's get into our second quick bit with Scarlett Johansson and Disney. Disney not only came out swinging, trying to indicate that Scarlett Johansson was a spoiled brat and she should be happy for the $20 million that she got and just sit down and be quiet and be like a good little Black Widow and not fight with them. But Disney has filed a motion in court that's going to be broken down, not this week, but next week on The Emily Show with more of a deep dive. But in some, they are saying, no. We have an arbitration agreement, so this needs to come out of the court and go nicely into arbitration. Do not fuck with us. We're Disney. To arbitration we go. We are not going to litigate this in the public court systems. Once it goes to arbitration, it goes behind closed doors with an arbitrator, and it gets dealt with in binding arbitration there. Disney had an arbitration clause with, not Disney, Marvel had an arbitration clause with Scarlett Johansson. Disney is arguing that the reason Scarlett Johansson is suing Disney for the inducement to Marvel to breach the contract is because she is trying to get around the arbitration provision in her contract with Marvel. But again, if you listen to last week's episode, and it's up on the channel as well, Scarlett Johansson's not suing Marvel for breaching the contract. She had a contract with Marvel. She's suing Disney for overriding Marvel and releasing Black Widow on Disney Plus, in addition to in theaters, saying that Disney had that control, not Marvel. It's a very interesting, like, the law of the thing is going to be very interesting because it is this inducement to breach contract. But if Disney induced them to breach the contract, she doesn't have an arbitration provision with Disney, but Disney's saying this is over the breach of that contract. That contract has an arbitration provision. So I think it will be interesting to see what the court does with this. This is just the beginning. Look, the denial of arbitration is something that will go up on appeal. And we're seeing this in, like, the James Charles employment lawsuit, right? We talked about the fact that it was a lawsuit that was filed. There was argument over whether it should go to binding arbitration. James Charles's attorneys didn't pay the arbitration fees, but then appealed the denial of arbitration. So this is like stage one. Depending on what the court does, it will probably be appealed, and that will pause the proceedings, and it will just go up on appeal, and we'll hear from it in a year and a half. This is going to be extensive litigation that is going to take time. The thing that's at play here is we have these multiple different corporations, but Marvel is a subsidiary of Disney. Even though it is its own corporate entity, it is a subsidiary under the Disney umbrella. But does the arbitration provision in the Marvel contract attach up to Disney? And that legally will be very interesting. This is not going to go away soon. I can understand why Johansson and her attorneys want this to be in the public forum, to just say, look, this is what they're doing to me. And I think that that is important to see. Now, Disney says in its filing on Friday that the lawsuit mischaracterizes the agreement. So as we do a deep dive into that agreement, we will see more from what Disney is arguing, because we have such a fast motion back. It was like Scarlett filed, Disney filed. And we'll get to talk about it both, and we'll see what the court rules. This will be back in court in October. Scarlett Johansson, through her loan-out company, Periwinkle, will have a chance to respond to this, and we will cover that reply as well. So it will be very interesting. It will be very interesting. Mother of Four Cats says, I take it there's no such thing as a quick litigation. There are some that are faster than others. This is not going to be one of them. Just litigation moving in its normal course of litigation is one thing, but the courts are all so backed up because of COVID anyway. So the civil courts and the criminal courts are kind of a mess with all of it. But there are litigations that can, in the normal course of things, just move along. There is a complaint, and then there is an answer, or then they say, hey, we're going to go try to mediate, not binding arbitration, but we'll try to mediate and then come back to the court, which is what happened in the Jeffree Star lawsuit with the estate of Anna Nicole Smith. The lawsuit was filed. They came into court and said, let us try to work this out. They went and worked it out and came in. So that litigation moved fairly quickly. The litigation in the Tati Westbrook KJ case moved fairly quickly. Like, there were a lot of motions filed, but it moved along fairly quickly. There will be a ruling on this, and then if it goes up on appeal, will be fairly slow. So that will be very interesting to see, and I will be keeping an eye on it. So this week's episode, if you don't follow the Emily Show podcast, I mean, according to Entertainment Tonight, it is a news entertainment podcast. It is. I mean, we talk about entertainment news, but from a legal angle. It's like legal plus pop culture meets awesomeness plus curse words. Law plus pop culture plus curse words equals amazing, I hope. So the podcast this week's going to be celebrating its 100th episode. And if you follow me on Instagram, you'll see a picture of how I wrecked my keyboard. It was quite a thing over the weekend and yesterday. But in the episode, you'll hear about why it's an episode with me and Dr. B. And I try to explain internet drama to him. We get very hung up on who is Trisha Paytas and why, who is Gabby Hanna and why is Keemstar like the nexus of like all of the drama that we talked about, because we were talking about the frenemies drama and we were talking about kind of Gabby Hanna. I was trying to explain what a Tana Mojo was, and we were drinking whiskey while that happened. So that happened. We are 24 minutes into this thing. There are over 3,000 of you in here. Are you guys ready to talk about all of these Duggar motions? just, I don't know what emoji, the little scales emoji, the law one. Throw a scales emoji in the chat if you're ready to go through five Duggar motions. Are you ready? I don't know if I'm ready. Like, I'm not mentally prepared. We have to talk about Josh Duggar. His defense team filed 5 different motions to either suppress or to dismiss. It's a lot to go through. I'm going to summarize most of these motions. We're not going to go line by line because we would be here for an eternity. I am not going to get into the charges of this case very much because it's not relevant. These are evidentiary motions. These are crim pro motions. This is like living your best 1L life, or if you took advanced crim pro, like my nerdy ass, living your best like 2 or 3L life. We're getting deep into the weeds with legal procedure, searches and seizures, the Fourth Amendment, what you can do, what you can't do. Some cases that if you were a law student at one point, you're like, oh, there we are again. Hello, friend. It's been a while since we've heard about you. It's interesting stuff, but we're not going to get too deep into the details of the case. So with Josh Duggar, I always do give a trigger warning. This is a case revolving around the possession of CP. I refer to it as CP. That is what the law calls it, though it is acknowledged within the filing motions that they are CSAI, but it's hard for me to say because I am so used to saying CP. So that's what the images are about. We're not going to get too much into that. We're going to get into the law of the thing and what his legal team has done. I think that Josh Duggar's legal team has done a really good job with these motions. I don't agree with all of the motions, but they are working. Now, everyone is entitled to a criminal defense. Everyone is innocent until proven guilty. Some of these are standard motions. Some of these are novel motions. They are working. And I will also say, if he had a court-appointed attorney, there's like one that I think might have been filed. I don't think some of the other ones would have been, but we will see. We will see. We're going to get to these and then we will get to your questions. It's just a lot. It's just a lot. Jen S. asked the first question, and since I am ADHD and get immediately distracted before I turn off the chat to talk about this story, would Duggar's defense team have access to the actual images since it's evidence? That is generally handled by the department, so they will easily get turned over the metadata and all of the stuff that tracks to it. But the actual images, they will generally have to go to where the officers are to inspect. Those are generally not sent out and not kept on a device or a thumb drive or something for someone else. So, generally, that's how that works, that you would have to go to the department to be able to examine it. And then you would get all the reports about it, not the actual images or not the actual videos, because some of these are videos. So that's not what we will. So yes, let's just jump into this. I'm going to go in the order that they filed these in. And that's how we're going. We're going from motion 36 to 40. So let's start with motion 36. I've pulled up the wrong one. Let's go to the ones that I actually highlighted instead of the ones that aren't, because then at least I have my notes. Let's go to the ones that have my notes. No, I had this all pulled up. I was very excited, and then no. And then I lost it. We're professionals here, people. This is just what happens. Where is it? No, I need the, yes. I try to be prepared, and then sometimes like stuff happens. All right. Oh, let's go. Motion number 36. This is a motion to suppress statements and requesting an evidentiary hearing. This is not uncommon. Jen Shaw made this motion to dry contact offense. Most defense attorneys, in most cases, if there is any grounds for it, any at all, are going to file a motion to suppress statements. This is a very common motion. This is on an interesting topic. When I did coverage, and that coverage is still on the channel, it is not monetized, but I did coverage of the detention hearing, and I was like, they are going to bring a motion to suppress statements based on him asking for a lawyer, and that's what we're here. Not based on dry contacts. This actually has more of a basis. I still don't necessarily think this is going to fly. my opinion, but I'm a former prosecutor. So, I understand why they brought this motion. I think they have room to argue this motion, and room to argue as a defense attorney in a federal case is literally the best you can hope for. Room to argue. You need to just be able to do a wiggle. Your Honor, can we get some of this evidence out of here? And the evidence we're talking about is, and we know this from the detention hearing, the defense does not say this in their motion at all, but the main statement that came before Miranda was, "Are you here looking for CP?" Said in more detail. But then there was an interview of an hour plus some length that they did. So they're trying to suppress everything that Duggar said when he was arrested. Not arrested, when they searched his car lot place. So motion to suppress under 12b3 and the Fifth Amendment, as well as evidence gathered as a result of those statements as fruit of the poisonous tree. So this is a big one. If the statements get thrown out and the evidence that came from those statements get thrown out, that could be evidence of, oh, my password is this, which is needed to kind of tie a connection to the computer and to him, things like that. So anything coming from those statements, not the things they got via the search warrant and the search at that time, but anything that the statements led them to can be thrown out if the statements are thrown out. So we will see. I don't necessarily think that's going to happen, but it's why you make this argument. You're not allowed to have fopped evidence. Fopped being fruit of the poisonous tree. Now it somehow fopped sounds like a dirty sound now. When I was in law school, fopped just sounded normal. And now fopped, I don't know, it sounds like WAP noises or something. But either way, it's fopped. Duggar's charged in a 2-count indictment, receipt and possession of CP. On November 8th, agents entered the business premises in Springdale, Arkansas. Let me make this a little smaller so it's not going back and forth. Identified themselves as law enforcement. One HSI reports that Duggar retrieved an Apple iPhone from his pocket and stated he would like to contact his attorney. The report continues. At the time, the special agents, ACOC, I'm not wrong. It says it. Like, why? Why? Aycock and Faulkner seized the iPhone from Duggar, and Faulkner explained that pursuant to the warrant, the device was being seized, and he would have an opportunity to contact his attorney at a later time. There's nothing unusual about that in this type of an investigation. You are not allowed to access your device. There are criminals that have kill switches on devices so that it will wipe absolutely everything. I've talked about a case that was brought up with when I was doing one of my trainings. I think it was training with the Secret Service, but it was one of the high-tech crimes trainings that I went to, and they were talking about a guy who had lined his doorways with magnets on the front of his house and the back of his house, so that when agents came in to seize all of the computer towers, when they walked through the magnetic doorway, it wiped all of the hard drives with the magnets. Like, they were that powerful. So it's, again, you can say to a jury, hey, why would you line your doorways with magnets if you don't want to do anything on the computer? But you can't show what was on the computer because it all got wiped. Normally, they will take phones and put them in Faraday bags, which is like a cage bag, so signals can't get in, so they can't remotely be wiped. It's a whole thing. And the way that they investigate digital evidence to preserve it is also a whole thing. They have special white rooms that are clean rooms that make sure that signals can't get in from the outside to remotely wipe devices and stuff like that. Look, the people who have the time to do all of this and are very clever about it, which is what I liked about white collar crime and high tech crime. Is it's clever. Like, it's clever the way that people go about covering their tracks, at least the ones who are quite good at it. So it's no surprise to me that when he pulled out an iPhone, they're like, that's on the list for the evidence. So we're going to go ahead and put that in this bag here so you can't delete anything off of it or use it. Then at the detention hearing, and I remember this too, this is also in my notes, and this is why I said when I covered it, oh, they're going to bring this up. This is going to come up in motions down the road, and here we are. Question: when you arrived, you testified that Duggar took out an iPhone out of his pocket and expressly told you and Special Agent Aycock he was calling his lawyer, correct? Well, he stated he would like to call his lawyer. He said he wanted to call his lawyer, correct? And this gets into like the Davis case, like, I want a lawyer, dog. we'll do the lawyer dog case another day, whether it's lawyer dog, DAWG, or lawyer comma dog, or lawyer dog like lawyer cat. But, give me a lawyer dog is a whole case where the syntax got discussed, but also is give me a lawyer expressly invoking your right to an attorney. And the courts are very interesting in the way they construe you initiating your right or your desire to speak with an attorney. We'll get into the case law as it is explained well in this motion. The defense attorney is asking, and he made very clear that the intention of taking out his physical iPhone device was to make contact with his attorney. Yes. At that time, before he could make contact with his attorney, you took his phone. That's correct. After Duggar explicitly said he wanted to call his lawyer, he wanted to call his lawyer. You know how the courts are going to parse this? He didn't say he wanted to talk to his lawyer. He said he wanted to call his lawyer. It could have been that he wanted to call his lawyer to say, hey, there are people here, or hey, come down here, or hey, how's the weather? So the courts will look at whether or not this invokes his right. Also, this is well before, it seems, they interviewed him. And that's going to be very much important in this, because he did not invoke the right while he was being interviewed. He said this when they arrived and they were starting their search of the premises. It'll be interesting if the government's motion describes how much time passes between this initial contact when they are starting their search and when they actually spoke to him. The more time, the more likely this is too remote from the interview for it to be him invoking his Fifth Amendment right, but we will see. And even here, they kind of acknowledge the time. It says law enforcement thereafter on the same day, but it does not say law enforcement thereafter within 15 minutes or immediately thereafter. Thereafter on the same day. I read this as being after the search has at least substantially concluded, which can take hours. They approached Duggar and asked if he'd be willing to discuss further details surrounding the issuance of the search warrant. They proceeded to question him inside a government vehicle where he and two federal agents were present. After asking him certain questions and before asking him others, the agents allegedly provided him with a statement of rights. That is his Miranda rights. So they provided him a Miranda waiver. In the government motion, I imagine they will say, well, he wasn't in custody. He wasn't taken into custody. The Miranda rights were given to notify him of his rights. And at that time, he did not say, yes, I want to talk to my attorney before going further. He allegedly initialed them and filled them out. We will see the details of that in the government response to this, the same way we did in the Jen Shaw dry contact motion. The agents then conducted a lengthy interrogation of Duggar. No attorney was present. The questioning was a custodial interrogation. They're going to argue that him being in the car was custodial. Law enforcement might say he was in the car because it was hot out, the air conditioning was on, and there was nowhere else to sit, or it was noisy and we needed to record it, and this is where we could record it. But at the beginning of the interview, we said, you're free to end this interview at any time. And he wasn't technically in custody. He was never arrested that day, et cetera, et cetera. I'm sure we'll see those types of arguments in the next motion. They go into Miranda versus Arizona, what the term interrogation means. It's clear they were questioning him. It's just whether he was in custody or not will be the argument that the government will make. They're arguing, of course, he's in a car, he's in custody, and saying the interaction involved law enforcement officers swarming the premises. Like I hear like they were swarming, like, I don't know, like the scarabs in The Mummy. They were swarming the premises. They took his iPhone out of his hand, and under the circumstances, it would intimidate anyone. Duggar communicated his intent to seek advice from his attorney. No, he did not. He said he wanted to call his attorney. That doesn't mean he wanted advice. He wanted to make a call. Like, one could try to extrapolate that he wanted advice, but it could also be, there's agents here. Just a heads up, just so you know. He could also want advice. So then, after preventing him from seeking legal advice and taking his iPhone, law enforcement approached him to interrogate him. Again, I think the fact that he did not, when he was given his Miranda warnings, did not then say, now, can I call my attorney now? Now I want to talk to a lawyer before I proceed with questioning. Again, the courts very narrowly construe this, whether for better or for worse. Just saying like lawyer, lawyer, lawyer. It's not Bravo. You can't just say lawyer, 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 fucking lawyer. and get a lawyer. You generally have to say, I want to speak to an attorney. I will not speak to you anymore. I do not want to speak to you anymore. I am invoking my right to remain silent. I am remaining silent, because generally just sitting there and shutting the fuck up isn't enough. You have to say, I'm staying silent. It's not like when you're not speaking to like your spouse and you're just like, I'm not speaking to you right now. You don't generally say, I'm not speaking to you right now, unless they don't get the hint. But this, with the federal agents, they don't get the hint. You have to say, I'm not speaking to you right now. Or more clearly, I am invoking my right to remain silent. I am remaining silent. I am not talking to you. And I want to talk to an attorney. Once you say you want to talk to an attorney, it's like if Michael Scott declaring bankruptcy actually worked. I want to talk to an attorney stops all questioning. But the law very clearly says stops all questioning. So if you say, I want to call my lawyer well before questioning ever starts, a lot of courts aren't going to find that as invoking your rights. They say the court should suppress the statements, because if you do continue an interrogation after someone has said they want to speak to a lawyer and they do not immediately cease the questioning, yes, throwing out the statements and any fruit of that poisonous tree is appropriate. But he wasn't being interrogated when he said he wanted to make a call to his lawyer. And I think that's what this is going to come down to for the court. They get into Michigan versus Harvey and Minnick versus Mississippi. They say in that vein, it bears emphasis that the issue is not whether the person then subsequently allegedly waived the rights following a Miranda warning, which Duggar did not knowingly, voluntarily, and intentionally do. They're saying he did not waive his Miranda rights. I suspect what the government will say is, no, he did waive his Miranda rights. Here's the signed Miranda waiver. Here's the audio recording of the Miranda waiver. But they're going to say, no, because he said, I want to speak to my attorney at the beginning of the thing, that means his subsequent waiver wasn't knowing and voluntarily and intentionally done. Let's see. They rehash the same fact scenario, saying that he never waived his rights to have that custodial interrogation. We'll see what the government argues, whether he waived them or whether they say that it's a non-custodial interrogation, which will be interesting. And yes, you can be in a car with law enforcement, not be under arrest, and have it be considered non-custodial. Those things generally break down on fact scenarios, and an evidentiary hearing might be actually ordered by the judge. The judge might not just do this on the pleadings, because it is an important issue. So conclusion, the bottom line is federal law enforcement egregiously and inexcusably violated Duggar's constitutional rights. Based on the record already before this court, suppression is necessary. However, to resolve these important issues, Duggar requests that this court conduct an evidentiary hearing to assess. And that really might just be the cleanest way for the court to do this on this motion, is to grant that evidentiary hearing and say, yes, we're going to have a hearing on whether the rights were invoked and whether he actually waived his Miranda rights. So the government's arguments, I think, will probably be in line with what I've already spoken to you about. Second motion. Wait, this is motion number 38. Where'd 37 go? There's 36. Where's 37? 37. Did my highlighted number 37 not show up? Nope. It did not export. All right, we're just gonna go with the clean copy. Fine. When you work with more than one program. Motion to suppress evidence and request for a Franks hearing. This is regarding evidence seized from the location on November 8th, 2019, to suppress all evidence that was derived from the information or items obtained during the search pursuant to the fruit of the poisonous tree doctrine. We already talked about FOPT, but it bars evidence which, though not obtained in an illegal search, was derived from information or items in that search. So basically, if you get information that's illegally gotten and use that to get a search warrant, everything coming down from it is poisoned. Relevant background is the same. This gets into a little bit of the IP address and the basis of the search warrant being how they got the IP address, and them arguing that I'm going to take some of this off the screen because it has the IP address on there, though it's the publicly available document, but still, they're saying that the 2 search warrants were gotten off of information that shouldn't have been gotten, and that because the search warrants were based on information that they shouldn't have had, then the search warrants themselves need to be yeeted out of court. They argue that based on the first search warrants for a residence, that the October 29th, 2019, the government sought and obtained a search warrant for a residence in Springdale, Arizona. The warrant was the result of an under oath affidavit signed by Special Agent Aycock, stating that on May 2019, the HSI Internet Crimes Task Force was conducting an online investigation of a BitTorrent peer-to-peer file sharing for offenders sharing the CP. Aycock attested that during the investigation, multiple files were successfully downloaded from an IP address. They give the IP address, and that within those files successfully downloaded, what they were and what the files were. More than 5 months later, Aycock stated in his affidavit that he then looked at the files and verified that they were the things that they were and what they were. As set out in the affidavit, they're saying that that is too long in time. On October 13th, 2019, they went to execute the warrant, but claimed they did not execute the warrant upon meeting the residence. On November 8th, 2019, the government filed a return saying that the warrant was not executed, stating no devices searched. So it seemed from the detention hearing that they chose not to execute the warrant at a residence because what they were really trying to get to was the car lot. And so once they got to the residence, they realized that that was not where the internet they thought was going into. And this was all kind of flushed out at the detention hearing, that originally they thought that the IP was going into this one, but it was going into the other one that were close in space. Another reason I don't think putting the address of the other location on blast is helpful, which is why this is not pulled up. So the second search warrant was for the business in Springdale, Arizona, and that business being the car lot. Again, tracking that IP address back to the car lot, the images that came from the IP address, and they're arguing that because of the mix-up there, you shouldn't be allowed to get the things that you got during the search warrant. They say that the government's May 2019 use of the torrent requires suppression based on the limited discovery disclosed by the government to date. This investigation originated in May 2019 based on Little Rock PD's detectives' use of a torrent, proprietary software that was created by law enforcement for use by law enforcement, which is not commercially available. The torrent has been the subject of various legal challenges focusing on methodology and general proposition, meaning it's bullshit that the government can surveil in this way and use this program to identify these images flying back and forth on the internet. And because of that, this should be suppressed. They argue that because the torrent software intentionally obscures the transmitted communication by encrypting the information and decentralizing the delivery system, the defendant's enhanced efforts to protect the privacy of the communications creates a reasonable expectation of privacy that might not exist with other file sharing programs. So the argument is, when individuals go to the lengths to use a torrent, they have a reasonable expectation of privacy in their communications online, even when those communications contain things that are illegal. And because there is a reasonable expectation of privacy, the government's use of this program that grabs that information when it's just randomly grabbing stuff before they have a search warrant violates an individual's reasonable expectation of privacy. Generally, the things that are flying around the internet, you don't have a reasonable expectation of privacy in. If I text someone, I don't have a reasonable expectation of privacy because that person could just be like, want to see the DMs? Let me screenshot them and share them. You know, the way you do on Twitter and the internet, apparently. I don't love it, but people do it. You don't have an expectation that that person's not going to take your text message and show it to somebody. There's no reasonable expectation of privacy in that. But they're saying if you go to the lengths to mask what you're doing on the internet, to hide using a torrent, that it's BS that the government can use their program to grab that because you expect the torrent to make it safe and to make it private. However, I think for me, the argument that there is any space on the internet that is private where you have an expectation of privacy for the things you're doing on the internet when you're communicating with another party, because that other party can share the information, I don't think it's well taken. But A for effort. Like, I understand the argument. The argument is you should be able to make your web searches private, and the government shouldn't be able to grab that info. I get it. I don't think it's going to work, but I get it. Let me get down to the next section. Again, the reason I don't have this, okay, this doesn't have the IP address on it as we get forward. The IP address is just up above. Yeah, but it has too much info. This whole motion has too much information about the things that they got. So they're saying that the courts in other cases have recognized that when law enforcement uses a device to track information, but especially when the device is located outside the judicial district where the device is being located, a warrant is required. But these types of cases come from putting tracking devices on people's cars and stuff. So is like going and physically popping a tracker onto somebody's vehicle the same as a program that monitors the internet? And if it is, then you need a warrant to monitor the internet. Law enforcement will argue we can't get a warrant to monitor the internet. We monitor the internet and then we investigate the things that we see. So this is going to be you should have gotten a warrant. Well, we don't have probable cause to get a warrant until we see the traffic that's happening. And once we see the traffic that's happening, we look at the traffic and go, oh, then we should get a warrant. So it's a surveillance argument, truly. And there have been tons of these. There have been arguments where law enforcement would use like heat registering devices or heat cameras that would show that like a part of a house was super hot, indicating like a grow area in marijuana busts, like back in the day when that happened. So you could see a grow room, but they would use them from either drones or from outside the curtilage of the property. So do you have a reasonable expectation in what somebody can see? But then it's like heat-seeking technology. So is it more than like the average bear would use? I think that this is probably going to fail, but I also understand the argument that the government just can't track everything that they want to track just because they have some fancy software to do it. They're arguing that at its core, the entire basis of the search warrant that got them onto the car lot, that got them to the other evidence, that got them to the conversation, at the heart, the reason the search warrant was argued for, the search warrant affidavit and the stuff at issue, was that a single video file with a name was successfully downloaded by law enforcement through a BitTorrent network on May 14th, 2019, and that a 65 image zip file was successfully downloaded on May 15th, 2019, and that the IP address associated with a used car business that caters to the general public and has numerous employees on the premises at any given time. So they're saying those three things aren't enough. The government's going to say, wait, there's more, but they'll have to make those arguments. Then they consolidated in the next paragraph. To be clear, law enforcement applied for the second search warrant on November 4th, 6 months after the torrent download. The affidavit contains no nexus between the downloads and any specific device. There's no evidence at all supporting right, because it's an IP address, the premise that the evidence of CP would be found at the location. Right, that's why they get a search warrant. They said that the affidavit was bare bones and that would not be sufficient. So they are challenging the entire underlying warrant based on reasonable expectations of privacy and based on the fact that they had no reasonable belief that 5 months after the thing was downloaded, they would find the devices that it was downloaded. And the government's going to have to respond to that. But this is it's an 88-page motion. It includes the search warrants. It's a very extensive motion, but mostly regarding Fourth Amendment law and whether or not they will kick out. If they kick out the search warrant, the entire case will be gone. So this is something that I expect we will see a very thorough reply from the government on. And if you guys want a deep dive on this one with regard to search warrants and how search warrants get issued, I did more of a deep dive on Jen Shaw's. We can do a deep dive, but we have what? We've been through 2. We have 3 left to get to. So if you want to deep dive into search warrant motions and search warrant affidavits and what the law says about reasonable expectation of privacy, we can get into this. So it's a very interesting approach to it, but also I get it. I get trying to liken this type of tracking to tracking on tracking on vehicles. I just don't know if this is going to fly with this court. So if this gets granted, they're not going to be able to move forward with this case. Let's get to the next motion. So that was motion number 37. Again, a well-argued motion, a well-put-together motion, something that I think these are kind of the typical things you're going to see a defense attorney attack the statements, attack the search warrant, because that's kind of cutting off the head of the thing. If you can get rid of that, you get rid of all the evidence that happened, and then there's no case, there's nothing to present, and then they are done. All right, let's get to the motion to suppress Josh Duggar's hands. I was surprised to see this motion. I'm not sure what they're getting at. I'm not sure what the government would use this for. I think the government will argue this is standard booking procedure, but the defense would like the photographs of Duggar's hands and feet, to be suppressed. I don't even know if they intend to use these. Normally, they take photos like this in booking to prove that there was not a struggle, that there wasn't anything that happened during booking, that he was not handcuffed or injured in any way during the booking procedure or the handcuffing procedure. So the defense here is arguing that these are not just a booking photo, that generally you need a search warrant to take photos. And that's true. If you're going to take photos of like tattoos on someone, and this happens in particularly gang cases and organized crime cases, if you're going to take pictures of somebody's tattoo, you generally need a warrant. You can't just make people strip and take photos of their tattoos, that because those tattoos can be considered incriminating statements. Oh my God. Okay. I'm going to tangent for a second. There was a defendant in a case that a DA I was working another case with who had information about one of the crimes tattooed across their neck. And it came down to like, did you need a warrant, or because it was visible in the booking photo, you didn't need a warrant? But there were lots of motions over the neck tattoo that essentially admitted to the crime, which was fascinating. Don't tattoo confessions onto your body. Maybe, just maybe. Back to Josh Duggar's hands. This motion focuses on photographs taken by law enforcement on April 29th, 2021, when Duggar turned himself in on self-surrender. The photographs depict his hands and feet from atypical angles taken during self-surrender. I wonder if this is their traditional booking practice. We'll see in the response to this motion. The court should suppress these warrantless photos. Generally, law enforcement must obtain a warrant that permits photographing of defendants' body parts other than simple booking photos. They're probably going to argue this is part of their booking procedure. So they cite the case law that gets into the fact that you generally need a search warrant for photos of the defendant's body. In this case, they're saying that Homeland Security gathered evidence, which means that they were required to get a search warrant to take the photos of the hands and feet. In filing this motion to vindicate Duggar's rights, the defense is in no way even suggesting that these photographs have any actual evidentiary value to the government. Well, good. At least in the footnote, we have acknowledged that these probably don't have evidentiary value. I don't imagine that they do. I'll be interested in the government's response and why they took these photos, if this is part of standard booking procedure. But they're saying, what you're not going to do is just take photos. This is he has rights, people. We have constitutional rights. So we're arguing the constitutional rights because they exist, whether it seems stupid or not. And I appreciate the footnote clarifying, look, this might not seem like much, but what you can't do is take photos without a warrant. They're not typical booking photos. And the government's probably going to say in their motion, these are typical booking photos. And this is why this is our booking procedure, because it shows that there was no cuffing or struggle or whatever. What you can't do is take these photos of one defendant and not another defendant. So it'll be interesting to see. So that's the end of motion 38. Let's get to 39. Oh boy. I am going to try to consolidate this motion. But this one is a novel for me, and I haven't wrapped my head around all of it yet. I'm going to be very interested to see how this goes forward. My initial thoughts are I want to email this to everyone in LawTube and be like, y'all look at what the fuck's happening in the Duggar case, because they're arguing that this is a motion to dismiss for a violation of the appointments clause of the Constitution. Okay. Did y'all know there was an appointments clause of the Constitution? If you're not familiar, I have an ASMR reading of the Constitution on my second channel. And you can hear me read the appointments clause, but this is based on the appointments clause of the Constitution. I have never seen a criminal case motion to dismiss based on the appointments clause. I read the heading of this at least 3 times and I went, wait, we're doing what? Also, that's not shade. The defense is putting in the work. Like, they are like work. And I have mad respect for that because work. When the evidence is bad, you work to get rid of it. So they are working, honey. But the appointments clause of the Constitution deals with literally that, how heads of departments and branches are appointed. They are in essence, I'm going to try to do my best. Okay. They are essentially arguing that the dudes in charge of Homeland Security during all of this investigation in 2019 into 2020 and till today, that the acting secretaries of Homeland Security during that time were not properly appointed. Therefore, the Department of Homeland Security, acting under the authority of the Secretary of Homeland Security or the acting Secretary of Homeland Security, does not have the authority to do their jobs because the people who were operating in charge of Homeland Security were not properly appointed. However, I don't know how to wrap my brain around the fact that there is also statutory authority allowing Homeland Security to do this that doesn't specifically come from the director or the secretary. So I don't know how, the defense doesn't really address it. I'm sure the government will in their response, and I'll cover their response too. But this is saying because the heads or the acting secretaries of Homeland Security were improperly appointed, it is a constitutional violation, and therefore the entire investigation of this case, the indictment in this case, everything just has to be thrown out. Homeland Security fucked up. Nobody who was investigated during 2019, 2020, and through part of 2021 can be prosecuted because of Homeland Security's error in their appointments. Now, that's not a result that most would be okay with because Homeland Security does have this giant task force dealing with exploited children. So a lot of us would be like, wait a second, that seems fucked. But if they're doing it wrong and it does negate their authority, then there's a point. However, I think that the statutory authority, meaning the law, the USC, the United States Code that grants them authority, is not harmed by this procedural issue. The defense is arguing this procedural issue is constitutional and your fucking rights shouldn't be trampled. And the fact that they didn't do it right means this whole thing gets yeeted. I hope that was a good summary. I hope that makes sense because good God, that I've never, but I am very, very interested. So I'm going to quickly go through this because, okay, let's see. This motion arises because this prosecution resulted from a criminal investigation conducted by the United States Department of Homeland Security. No argument there, that happened. During which, at all times, the agents investigating Duggar were working under the authority of purported acting Secretary Kevin McAllen, I think. McAllen? We're going with McAllen because it's easier for me. Sorry, Kevin, no disrespect. With peace and love. And purported acting secretary Chad Wolf. Chad's name is just easier, but of course he's Chad. Chad did it wrong, they're saying. Chad, what did you do, Chad? They go back to the detention hearing transcript. Question, this was an HSI case, a Department of Homeland Security case, correct? That's correct. Yes, sir. And this is the transcript again. Question. Okay. And so at all times you were working under the authority of the Department of Homeland Security and whoever was in charge, correct? That is correct, sir. Well, I mean, that's their understanding, but the authority comes from the US code, but okay. So, however, the United States Government Accountability Office, the GAO, correctly found in August 2020. I like that they just put their opinion in there. You're right, GAO. I also love that the attorneys stayed up on all of this. Like the amount of work, the amount of mental gymnastics that has gone into bringing this type of motion in this type of proceeding is commendable. You know, go for it. It's not frivolous, which I appreciate, and it's not just a lot of it. We're kind of throwing some stuff to the wall to see what sticks, but also in civil cases, I get annoyed because you're wasting everybody's money. But in criminal cases, when you're facing prison, I'm like, throw it to the wall. Like that's the job of the defense attorney. So that doesn't annoy me at all. It might annoy the AUSAs who are like, how in the fuck do I respond to this? The United States Government Accountability Office correctly found in August 2020, upon Secretary Christian Nielsen's resignation on April 10th, 2019. Remember, these images are from May 2019. So this investigation started the month after when those images were allegedly transported through the interwebs and intercepted and all. The official who assumed title of acting secretary had not been designated in the order of succession to serve upon the secretary's resignation. Because the incorrect official assumed the title of acting secretary at the time, subsequent amendments to the order of succession made by that official were invalid, and officials who assumed their positions under such amendments, including Chad Wolf and Kenneth Cusolini, were named by reference to an invalid order of succession. So here's what that means. After the resignation, other dude took charge. Some dude did it. And he changed the order of succession. So he said, okay, when there's a vacancy in the position of secretary, who the acting secretary is this the head of this office, this office, this office, this office. But they're saying because that person was not the right person to be in charge, that person didn't have the authority to change the order of succession. So therefore, the people who were subsequently acting secretaries were not the appropriate people. Therefore, all of this should be thrown out. All of it should be thrown out. Again, there's also statutory authority for the officers to do their jobs. I don't think an issue with the order of succession and the appointments clause overrides the statutory authority to do the thing, but generally constitutional authority does override statutory authority. A, not a constitutional law scholar, and B, never seen this argument before. Fascinated to see what case law the government researches, because what I'm also not is a constitutional law research attorney. But I am going to be looking into some of the cases they cited because I want to read them for myself to see what propositions they stand for. So they get into the relevant background. Again, during the detention hearing, this is an HSI case. There's no argument that this is a Homeland Security case and that the agents were acting under one, statutory authority, but two, also the authority of the director of the department. That this, between December 5th, 2017 and April 10th, Secretary Nielsen served as the presidentially appointed Senate-confirmed Secretary of Department of Homeland Security. But when she resigned before this investigation, this is what a mess Homeland Security was. The deputy secretary position had been vacant since April 14th, 2018. The undersecretary for management resigned April 10th, 2019, leaving that position vacant. Undersecretary Nielsen's resignation on April 10th, 2019, the Commissioner of Customs and Border Patrol purportedly assumed the title and position of acting secretary of DHS. And on November 13, that individual resigned and then the Undersecretary for Strategy, Policy, and Plans purportedly assumed the title of acting secretary of DHS. And then Wolf was the head of DHS until he resigned January 11th, 2021. The appointments clause of the Constitution, let's just
The president shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors and other public ministers and councils, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointments of such inferior officers as they think proper in the president alone. They mistyped that, in the courts of law or in the heads of departments. U.S. Constitution. To mistype the Constitution, though, that part of it, I'm offended by that part. It's one letter, and they're like close in space to each other. So that is the appointments clause of the Constitution. They talk about the fact that you need to be appointed and confirmed by the Senate. We're all well aware of how Senate confirmation works at this point. We've gone through it with multiple Supreme Court justices in recent memory. It's the same for other secretaries of large departments. They talk about the Federal Vacancies Reform Act. I'm not going to break down the FVRA, but Homeland Security has its own procedure separate from the FVRA. They talk about what the department found should have happened and who should have done the thing. They talk about the unlawful succession and then say, this constitutionally stunning house of cards at DHS continued to crumble. I appreciate the snark of the constitutionally stunning house of cards. Well played. On November 8th, the order of succession was changed. That one then deputy secretary, right? Well, it seems that the deputy secretary would become the secretary. That's how it always works. It's like lieutenant governor becomes the governor. Undersecretary for Management, Commissioner of the CBP, Undersecretary for Strategy, Policy, and Plans. They're saying that wasn't the order before, and he didn't have the authority to change it. Therefore, everything gets yeeted. Let's see. The proper remedy is dismissal. In rare but important instances in which the Supreme Court has found a violation of the Appointments Clause, you better fucking believe they're rare. I'm going to have to look. I want to know how many cases the Supreme Court has heard based on the Appointments Clause. It can't be many. In rare but important instances in which the Supreme Court has found a violation of the Appointments Clause, the court has rejected the notion that the individuals should nevertheless remain subject to the actions of those who acted without power. So the argument being that the improperly appointed secretary neutralizes or invalidates the entire department, not just that individual's action, is what they're arguing. Invalidating actions by individuals given authority in violation of the Appointments Clause, also United States versus Providence Journal. Dismissing for lack of jurisdiction because the special prosecutor lacked the statutory authority to represent the United States in a petition for a writ of cert. But that makes sense because it's the special prosecutor is the one acting and they don't have the authority, which is distinguishable than here. This Landry case, violation of Appointments Clause constitutes structural error. However, does that, when there's underlying authority in the code, does right? This is actually an interesting constitutional question. Whether this will yeet the entire case, I am unlikely to think so because there is still statutory authority, but the constitutional argument is fascinating. In filing this motion, Duggar readily acknowledges that this is an unusual constitutional challenge in a federal criminal prosecution. No shit. But that should not factor in the court's analysis. Also fair. Rather, the court should conclude, well, thank you for telling the court what to do. Your Honor, do this. The court should conclude that what the GAO and the district court have already concluded, that the head of DHS at all relevant times during the DHS HSI investigation, in this case, was occupied by two people without lawful authority. Again, I don't think that's going to invalidate every action taken by the entire department, but I appreciate the effort, and it made my brain go, wait, what? So I appreciate the opportunity to go, things that make you go, yes. I'm very interested to see what case law the government brings in their response. I will be very interested to see how the judge rules on that, because the judge is also going to be like, interesting. The Appointments Clause. Never have I ever
had to deal with a case regarding the appointments clause in a federal prosecution. Interesting. And it makes, I wonder if Jen Shah's lawyers are like, hey, Homeland Security was involved in ours too. But the investigation started before 2019 from 2012. But we haven't seen this motion in the other federal prosecutions that we're tracking, which is also. All right, last motion. Docket number 40, defendant's motion to dismiss for the government's failure to preserve potentially exculpatory evidence, which, the government has to do. It's a Trombetta motion, you all. Put Trombetta on your bingo card. The lawyers are like, oh, Emily. And everyone else is like, what the fuck's a Trombetta motion? Yes, this. The due process clause requires that law enforcement preserve evidence that is either facially exculpatory or potentially exculpatory. You cannot yeet evidence that might exonerate the defendant or prove that they didn't do it. I have not reread Trombetta. I think it was the case with like a coat check ticket in a pocket and it wasn't preserved and it would have shown that the person was somewhere else that they should have been. But the government has to preserve evidence. The times I've had issues with evidence being preserved, I can tell you I have never been more pissed. Then I'm like, well, where'd it go? I don't know. It was an evidence. It didn't get saved. It got destroyed. What do you mean? What in the fuck do you mean it got destroyed? No, it does happen. It shouldn't happen, but it does happen. I don't know if that's what happened in this case, but again, when the evidence is bad, you attack the evidence, and that's what's happening here. We know the relevant background of the case. We know the search warrants were issued in the case. We talk about the search warrants on the other motion, but these are search warrants for witnesses. So they named the witnesses by witness 1, 2, and 3, which I appreciate that this is a high-profile case, and the defense actually went the extra step to say to the court, in their footnote here, footnote voice, given the nature of these proceedings, Duggar is using the pseudonyms witness 1, witness 2, and witness 3 in lieu of these individuals' names. However, Duggar has no objection to identifying each of them by name if the court prefers. I appreciate the use of witness 1, 2, and 3. The public generally doesn't need to know. The court knows who it is. The government knows who it is. They're arguing that all 3 of these witnesses were interviewed and that their cell phones were searched for potential criminal evidence, so that there was a look at their phones. It does not seem from this motion that any of the devices were taken to forensics. It was a cursory blow through of the phones to see if there were any, I would imagine, torrent browsers, et cetera, et cetera. So that is what they are arguing with regard to all 3 of these witnesses, that they examined it visually and that they said that there was no evidence. So the fact that they kept saying there was no evidence, they made a report that said, we looked at the phone and there was no evidence. Duggar's arguing, just because you think there's no evidence, the phones might have been in certain places at certain times. There's metadata on the phones that we need to know. I think the government will argue, look, we had the IP address, and by the time we interviewed these 3 witnesses, we had already identified that IP address to the location and to the device. So we knew these devices didn't match the IP address. So we knew the devices weren't related to that. We were looking to see if there was any tangentially related evidence. And these were all searches based on consent, where they said, can we look at your phone? Not based on search warrants. And the defense is arguing that 2 of these witnesses were read their Miranda rights before they were interviewed. And it'll be interesting to see if the government explains why they were Mirandized. Were they Mirandized because they thought they had evidence in this case? Or were they Mirandized, you have the right to remain silent, blah, 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 because the government thought their phones might turn up evidence of something related? So again, these are crimes of possession that are being charged. But if they'd already identified the IP in the device, then yeah, this phone's not going to be the IP or the device. But the defense is arguing, but that could have evidence that shows that they could have been the ones using the Wi-Fi at the car lot. It's a car lot. Other people come onto it. Due process clause requires dismissal of this case based on the government's failure to preserve potentially exculpatory evidence. And of course, the government saying there's nothing on these phones. The defense is saying, right, but we have a right to know what's on the phones, because you might think it's nothing, but it might be potentially exculpatory for us. And so if they do a hearing on the motion with regard to the statements and whether or not that was in violation of the Fifth Amendment. I think they might also do a hearing on this with regard to whether it's a violation of the Fourth Amendment. I might revise that when I see what the government has to say about how this all went down. But the defense is arguing under Youngblood, the other case that goes along hand in hand with Trombetta, that where the evidence the government failed to preserve is potentially exculpatory, could be exonerating, could help the defendant say, see, not me, because the defendant doesn't have to prove somebody did it. The defendant just has to prove not me did it. I don't have to prove to you that so-and-so did it. I just have to prove it wasn't me, or that beyond a reasonable doubt it wasn't me, that you might think it's me, but it could also be them. And that could also is the reasonable doubt. Dismissal is mandatory if the government acted in bad faith in destroying or failing to preserve. They're, of course, arguing the failing to preserve. They're not arguing that anything got destroyed. They cite the Ninth Circuit, which is not the governing circuit of this particular court, but a noted case. They talk about the searching of the cell phones, that they used forensic professionals to search the phones, even though it was just a visual search. So it's like, well, why wasn't there a forensic search done where the phones were imaged and preserved and could be then examined by the defendants? At the bottom, investigators purposefully searched these devices, but did so in a way that failed to preserve any evidence for defense's use. Instead, the government only turned over documents with law enforcement's conclusions that the devices had negative results. But this is far short of what the law requires, that exculpatory evidence be delivered directly into the hands of the accused to protect the innocent from erroneous conviction and to ensure integrity of our criminal justice system, from Trombetta. So arguing, here's the thing though, if they had taken the phone after they had gotten negative results and then tried to do a forensic on the phone, they would have had to get a search warrant, but they're saying there's no results on the phone, so they couldn't have gotten probable cause for a search warrant, so they couldn't have done a forensic search on the phones because they wouldn't have had probable cause to do a forensic search on the phone, and they would have needed a warrant to do the forensic search on the phone because they said, can we take a look at your phone? They didn't say, can we do a full forensics on the phone? So I'll be interested to see what the government argues, because if these defense attorneys were the defense attorneys of the witnesses who had the forensics done on the phone, they would have said, yeah, but you didn't have the authority to, you did not have the authority to do that. You did not have the authority. Tech has reminded me that I have not asked in the 1 hour and 20 minutes we've been live with 4,000 of you on to go ahead and hit the subscribe button, because we are very close to hitting 150,000. So if you all would like to make it bing for the fact that I have read so many motions, your girl would appreciate it. Go ahead and make it bing. Make it bing. And leave a comment if you are a new subscriber, or if you're an old subscriber that doesn't know if you're still subscribed. Go look, make it bing. All right. Authority. Let's keep going. So they're talking about the bad faith cases. We don't need a recitation of the law, because for all of our purposes, it will be very, very interesting to see what the government responds to. They go on to say that what happened here is as clear as it is troubling. The government concluded that these 3 devices they searched did not further its case against Duggar, and therefore they deprived Duggar of the opportunity to access the potentially exculpatory evidence. Furthermore, to the extent any of these 3 witnesses testify at trial, the government failed to preserve possible impeachment evidence. Impeachment evidence meaning that you can use it against them, saying, yeah, but on your phone it said this, and on your phone it said that. So we will see. Again, this is the defense's perspective of this. What the government says will be coming in their responses. Indeed, the government's obligations under Brady encompass not only information that is admissible in its present form, but also material information that could potentially lead to admissible evidence. Conclusion based on the foregoing: yeet everything, yeet all of the things, because that's really the only point of any of these motions, is to yeet the things. We're not going to go through the search warrants. The purpose again is to attack the evidence, attack the warrants, attack the constitutional basis, attack the statements, and try to get as much of the evidence out of the case as possible. And they've done a really good job at attacking it. I think most defense attorneys might not have gone for the appointments clause. It's novel. It would have taken a lot of work and probably a lot of money to put that motion together. But a lot of attorneys, I mean, most attorneys, would go after suppressing the statements, maybe not the hand photos, but suppressing the statements, suppressing the search warrants, and suppressing the evidence. Those things would, are kind of expected in the natural course if somebody's not intending to plea. However, they might throw up all of these motions. The deadline for a change of plea in this case is coming at the end of October. So this is the defense saying, okay, if all of these motions don't go the defense way, they might then be more amenable to be like, okay, if all of this evidence is coming in, now can we have that discussion about changing plea? But this is definitely the defense trying to remove as much evidence from the case as possible and making some good arguments for it. Again, the argument with regard to the statements, I think it's too far in time. The appointments clause is going to be really interesting. I think the statutory authority is not going to be overdone by the appointments, but I don't know. I'm interested to see. With regard to the exculpatory evidence, I need to see what the government has to say about what evidence there was, because I understand the defense's argument in that. So we'll see. Oh my goodness, it's like an hour and 25 minutes in. We're going to have to get to the Tati stuff real quick, and we will do more of a deep dive. More of a deep dive on another day, because it's, again, you guys, it's so much stuff. So let's go to this hearing that they had first, and I'll go to the transcript of the hearing to kind of get the answers and then work backwards from there. Hopefully that sounds good to you, sounds good to me. We're going to pull up the transcript of the hearing because we don't have a ruling on this hearing yet. So let's get into Tati Westbrook and Clark Swanson and all of the things. This is regarding the Nevada lawsuit, Halo Beauty Partners versus Clark Swanson. Halo Beauty Partners, now at this point, ostensibly being run by Tati Westbrook and James Westbrook. They have purportedly fired and yeeted their business partner, Clark Swanson, as CFO. He has not been fully removed from the company because he still is a 1/3 owner. This is part of a trilogy of lawsuits. There is the lawsuit, the business partner lawsuit that started it all, that was filed in October in California, the business partner suit. This is a lawsuit because of the defendant's greed. That one, that lawsuit, that's still in Los Angeles pending. I need to go look at it because that motion to dismiss should be coming up this month. No, next month. So that motion to dismiss is now right around the corner. Then the KJ suit was filed and then subsequently is gone. Then Swanson filed a suit for defamation against the Westbrooks in Washington State. Then Halo Beauty Partners sued Swanson in Nevada. Then they filed an amended suit. Then they filed a motion for a temporary restraining order and an injunction, essentially seeking the turning over of corporate documents. They have terminated Clark Swanson as CFO. He said they didn't have the authority to do so. They don't have access to all of the things that have been happening and that the CFO has been doing. They say they don't have administrative access to the QuickBooks accounts, to the American Express bills, and all of those things. So this is really a fight over turning over the corporate documents, the checkbooks, the accounts, the access to the accounts back over to the Westbrooks so that the company can continue to run while this trifecta of litigation is running its course. The transcript from that October 13th hearing was filed October 17th, and we've pulled it up, and now we're going over it. Oh, wait, this isn't the one is this the one I highlighted? Nope. Let's keep pulling up the wrong version of things. It's super helpful because there was stuff that I found interesting, and I would like to shortcut this because we don't have a lot of time. We're gonna hit the highlights. We're gonna hit the highlights if it will let me hit the highlights. So where is my transcript? There it is. All right. When you think you're prepared and then you're like, oh wait, this is why I could stream for like 4 hours. We could just chit chat, answer questions as we go. All right. Lawyers present. Maximilian is present. He's local Nevada counsel for the Westbrooks, and then Queen Levine and Saltsy. James Shapiro is appearing for defendant Clark Swanson. They all appeared via the Blue Jeans app, which is kind of like a Zoom thing. Las Vegas, August 13th, 10:39. Maximilian, good morning, Your Honor. Maximilian, we're just gonna Max with peace and love. Maximilian's such a fucking cool name that we're gonna call you by your first name because it's cool. And Queen Levine already has the best nickname, so that's kind of that's kind of what it is. The Westbrooks were appearing via Zoom. Co-counsel was present, but counsel that was local counsel was the one who spoke for most of this. Counsel for Clark Swanson made their appearance on behalf of Clark Swanson. Mr. Swanson's also appearing. So the Westbrooks were on the call. Swanson was on the call. Everybody's on the call. They took care of the motions to associate counsel, which means they let the attorneys come into Nevada. It's like the Pro Hoc Vice. So the counsel associated for the purposes of appearing. This happened in the other cases as well, where attorneys who are licensed in one jurisdiction will be allowed to practice in another jurisdiction for the limited purpose of that particular case for that particular client, so long as they also have local counsel with them. Because you have the right to choose your lawyer. The court said, good enough, let's take a request for the TRO. And it's not to take the wind out of your sails, but when the facts are in such dispute, it's difficult for me to do this without an evidentiary hearing. That being said, and then counsel spoke up and said, look, yes, there are facts in dispute. Swanson disputes a lot of the facts. Swanson's 400-page opposition basically rehashed the entire LA lawsuit, saying, no, the way they see it is not the way I see it. I think the Westbrooks counsel did a good job of saying to the court, no, we know there's facts in dispute, but the thing that's not in dispute is that we don't have access to the documents for our corporation, and that's all we want. We want the corporate documents. Tati's attorney, Maximilian, says, we certainly recognize that, yes, there's a lawsuit out in California. Swanson is making arguments about other endeavors that he believes belong under the Halo brand. That would be the makeup. There's an interesting document attached to Swanson's objection that we'll get to. We, of course, disagree with that lawsuit out of California. There's no residency in California. The California lawsuit. We're here today with the Nevada LLC operating under Chapter 86 in Nevada, talking about why there's only one thing that's not being disputed that plaintiffs concede, and that's the preserving the status quo. That's why we're here, is to preserve the status quo of the corporation, to let the corporation keep operating. Swanson's no longer performing as CFO. He's no longer CFO. He no longer has access. And we have since stopped payments for his in-laws for the purpose of Halo Beauty Partners LLC. So we agree with all of that. So that's why we believe preserving the status quo in an injunction TRO is warranted in this case. We still do not have access to QuickBooks, customer support, voicemail, corporate checkbooks, registers, bookkeeping records for 2021. James Westbrook's taken over CFO duties. And he needs Swanson to not be representing himself as CFO of the entity, which per his papers, he conceded that's the status quo as of right now. The defense then argues that no, they don't have the authority to yeet Swanson, so it's not the status quo, and that Swanson should still be the CFO. That would be the status quo. The court disagrees down the road. Your Honor, we have an attached email from American Express, the representative who confirmed that we don't have access to the information because they are account holders, but they are not on the account. They're trying to get access to the account from Swanson to see what was spent. It seems that the heart of the issue is that the American Express, everything that was put on the American Express, it's always American Express, like the $14 million to Erica Jane on the American Express. But it seems that the American Express wasn't broken down, and the Westbrooks don't know what was spent on the American Express and want to know what's on the American Express because they're trying to figure out exactly what is going on financially with this corporation. They then get into Swanson's not denying that he spoke to Paulson, spelled phonetically by the court reporter. They get into gossip and they get into that stuff. The court said, I've read everything. They get back into the fact that Swanson didn't deny in his papers the failings of CFO, the expenses and the K1s and stuff like that. They said there's irreparable harm taking place because they don't have access. That, the payroll company had people added to it that they didn't approve, etc. The court then goes to Clark Swanson's side and said, look, they took 7 minutes to get through that. You have 7 minutes to get through this. And Swanson's lawyer said, the question that I have right now is, why are we here? What WTF, Your Honor? Why are we here? They haven't articulated what they want. What they've described to you in oral arguments today is a discovery dispute over documents. They want you not to issue an injunction to prevent my client from doing anything, but to issue an injunction that orders my client to do something. That's what I heard. We need access to the books and records. which they already have, but that's beside the point. So they're arguing that that Swanson has allowed access. The Westbrooks are saying that they don't have access. They're saying that the status quo would be leaving him as CFO, that they want him to stop holding himself out as CFO. Swanson, through his counsel, argues, well, first of all, Your Honor, we have presented evidence that demonstrates they don't have the ability to remove him as CFO. So if you're going to maintain the status quo, then he should be the CFO. They have additional fatal flaws. The complaint doesn't seek injunctive relief on the complaint. It does not. But you can still seek injunctive relief even if the complaint doesn't. So if there is an injunction, Your Honor, we have set forth that the bond would need to be $55 million. $55 million. Here's what a bond is. We talked about injunctive relief, and it was kind of clear in the Nike Satan shoes case. Nike said, Your Honor, generally injunctive relief is stop right there. Stop right there. Thank you very much. I need somebody but injunctive relief, stop doing some shit. In the Nike Satan shoes, it was stop selling the shoes, do not ship the shoes. And Mischief is like, they're already gone. So bye. But you have to post a bond in case the injunctive relief was wrong, in case it harms the other party, and that down the road, the evidence proves that the injunctive relief shouldn't have happened. This is also happening in the Haley Page case. They gave her Instagram account over to her former employer saying, no, this is a business account. This is what the bond is, in case at the end of all of the evidence, it's shown that she should have had the case, then she gets the injunctive relief and the bond. So they're saying the bond in this case, if they turn over the access to the books, should be $55 million, which means if the Westbrooks want to enforce this injunction, if the court grants it, they would have to put up, or the company truly would have to put up $55 million. Okay. Okay. But at the end of the day, this isn't even related to their claims. This is a discovery dispute. It's inappropriate. They have not met the standard, and their motion should be denied. The court, I have a few questions for you. Swanson's counsel, yes. Mr. Swanson is now removed from the accounts. Shapiro, that's what I've been told. The court, I picked it up in their opposition. So, yep, is that correct, Maximilian? Your Honor, to some of the accounts, yes, the bank accounts. But again, as I've noted, he's maintaining control of the American Express, where a lot of the expenses have been funneled through. The court, all right. Shapiro, that we don't have access to, dealing specifically with the Fisher's insurance and benefits and the conversation of assets, that we would have no ability to just recognize or understand. The court said, I got it. Mr. Shapiro, is your client handling payroll now? That's Swanson's attorney. I'm sorry, excuse me. Is your client doing anything with the payroll? No. Okay. Maximilian, that's not true, Your Honor. The Monday after he was removed as CFO, he authorized payroll. The court, well, they dispute that he could be removed, so okay. Saying again, well, yeah, he authorized payroll because he said, yeah, you can't fire me. No, I'm not leaving. You can't make me. I'm going to still authorize payroll. Swanson's attorney said, my client's not trying to hide anything. We attached an email where he asked American Express on August 10th. He sent an email to American Express to confirm they have access. He's not trying to block them. They all have access. If they don't for some reason, let me know. We'll get them access. That's not the issue. The court said, Maximilian, that's incorrect, Your Honor. We contacted the same American Express representative asking for access to the account, and they were told that we could not have access and that Mr. Swanson was the only one who could permit access, and that happened yesterday. What about the 2021 bookkeeping? We don't have access to the register, the checks, the checkbooks, the check registers, or QuickBooks. We don't have administrative access to QuickBooks. That was listed in my client's affidavit that was filed last night. And the court said, all right, I'm going to order some interim relief for the purpose of stabilizing the company, both in the meantime. I intend none of this to have any effect on the California litigation at all. And in that, I need to be really specific about that. The defendant shall grant access to the QuickBooks, checkbooks, books and records accounts to the plaintiff, which will include all of the 2021 bookkeeping. The American Express statements shall be provided to plaintiff, and plaintiff shall be given access to American Express with regard to any agreements that Mr. Swanson made with third parties. That information will be turned over to plaintiff. We also have PayPal, ? Your Honor, we've taken care of that. It's in Westbrook's name. good enough. I'm going to set the bond for $10,000 for the protection of the defendant here, simply because I assume he's going to have to incur attorney's fees resolving this. I'm going to direct the parties to work together to see if they can cooperate so that the business is stable in the meantime. I'm going to ask you also to consider consolidating on the merits and just try the case, bringing all the cases together and consolidate them and try them. And we can do it this fall, the judge. We can do it this fall if you think you can. And if I'm getting a look of horror here in the courtroom, so the judge is looking at the lawyers going, I'm getting a look of horror, because the judge is like, we can just try this in the fall. You've all said a bunch of shit. You're all going like this together. Fuck it. Consolidate the cases here. Let's just go to trial. Let's just go to trial. Let's just do it. Let's move on. We can do it in the fall. I'm ready now. Bring it. Let's go. If y'all can't work together, the only way to solve it is to go to trial as fast as possible. So let's just do that. I love this. I love that the judge noted I'm getting a look of horror here in the courtroom. Probably Mr. Shapiro is the same, but I always try to do that on an expedite business matters. Maximilian, I appreciate it, Your Honor. I know you've handled many disputes like this before. I appreciate your insight. Certainly we'll discuss that. I'll task Maximilian with preparing the order. So plaintiff to prepare the order. Shapiro, you will have the ability to review and approve the form of the order. I don't accept competing orders, which means the plaintiff would say, this is what the court said, and the defense would say, this is what the court said, and then the court would have to like either merge them together or grant one and not the other one. So the court said, I'm not accepting orders from both of you. So if you object to the form of the file a written objection to preserve your record. Anything else? Thank you both. And the defense has in fact filed an objection to the order saying, look, what you're trying to file is not what the court said. And so there is already a dispute over what this TRO will require the turning over of, and that's already being objected to. So that's why we haven't seen an order yet. Now at least we know why we haven't seen an order, because there is still litigation going on over the order. The defense filed a 9-page motion saying that the order does not say what the court said. And we just talked about what the court said, but the defense is arguing that each paragraph implies that the court found Swanson was interfering with the business, and or that Swanson has no right to or justification to be involved in plaintiff's business, neither which is true. Second, this is not a basis on the court issued the relief. So paragraph 1 said, the right to carry on lawful business without obstruction is a property right. Well, the court did not say that. And acts committed without just cause or excuse, which interfere with the carrying on of plaintiff's business or destroy its custom, its credit, or its profits, due an irreparable injury, and thus authorize the issuance of an injunction. What is happening, though, is that the plaintiff is trying to set the legal grounds for what the court did. So the plaintiff is like, this is why the court's allowed to do it. They're saying, no, that implies something was wrong here. But this is a quote from a case. So this is a quote for legal authority saying, no, the court has to have legal authority. The court can't just do whatever. So this is the legal authority that the court is using. And that goes on and on and on for each paragraph. So at some point, they're either going to have to submit the order and the objections, and the court's going to have to decide, or they're going to have to come together and submit a different order. So we will go over the final form of the order, because it seems that is going to be fought out. It seems that everything's going to be fought out. So this is a 34-page motion because it includes the entire transcript we just went over. But there was one other document I wanted to get to, and we'll get to the rest of we'll get to more nuggets from this opposition when we do the defense's motion to dismiss, because there were so many Duggar motions today. And I know that's what a lot of you wanted to talk about because it was so timely. But in the opposition to the application for temporary restraining order, Clark rehashes the entire LA lawsuit. They did call James Swanson, not James Westbrook, which I thought was funny. But they also included notes from a meeting that we have not seen before. What we have seen in this case and in the LA case is we have seen the amended corporate documents that say what Halo Beauty is, what Halo Beauty does, and limits people's behavior with regard to competing nutraceutical businesses, supplement businesses. How many times can you say nutraceutical? Every time we talk about this case, it's like, don't drink every time I say nutraceutical. We're going to just start saying supplements, vitamins, the vitamins of it all. But they Swanson attaches notes, a declaration and notes from one of their meetings that I found very interesting, because the notes from the meeting actually, and we'll do his declaration. Do you guys want to do his declaration? I mean, we have a little bit of time. If you want to hear Swanson's declaration, go ahead and pop purple hearts in the chat and we will do it. If you want to hear the declaration, we'll get to it. It's not super long. So purple hearts, purple hearts. But this document we have not seen before. And this is a minutes of the special meeting. So this is the meeting that happened in Marina del Rey when they were talking about what Halo Beauty is going to be. Now, these are notes. These are minutes from the meeting. This was then memorialized in a corporate document. Some of what's in this is left out. I see all of the purple hearts. Okay, we'll do that in a minute. But in the meeting notes, they do talk about the changing. Now, Clark wrote these, but they talk about the changing of the ownership from 50-25-25 to 33-33-33. They talk about social media. They talk again about Jeffree Star and James Charles and Manny MUA and Laura Lee. Like, oh, if we could all just transport ourselves back to a time when YouTubers all got along with one another in the beauty space. They talk about the trademarks and the products, but they talked about approvals. Miss Westbrook moved to approve the changes discussed. Mr. Westbrook and Swanson were in full agreement. The motions were carried unanimously. Business name to be named Halo Beauty. Expanded focus. Halo Beauty will not only make vitamins, but is the sole exclusive brand of Miss Tati Westbrook. That's what's being alleged in the LA lawsuit, that it was the sole exclusive brand of Tati Westbrook. Now, that's in these meeting notes, but it did not move into the corporate structured documents. So what I'm left asking is, what happened between this and the formal corporate documents? What changed in there? Because in the meeting notes, he has put it in here. Expanded focus. Halo Beauty will not only make vitamins, but is the solely exclusive brand of Miss Tati Westbrook. This is where lawyers will fight over what solely exclusive means, and the fact that the minutes do not reflect what was actually memorialized in the corporate documents, and the corporate documents are the best evidence of what was decided, not the minutes. But this is the crux of the argument in the LA suit. Beauty industry product lines include, but not limited to, supplements. It doesn't say nutraceuticals here. Supplements. Supplements, ingestible beauty, skincare and cosmetics / makeup, and other product lines such as a wet line, which I have since learned means shampoo and shit. Stuff you use in the shower. Brilliant. I was so confused. I was thinking like wet room, because those are the types of shows that I watch. But no, not a wet room where you kill people. A wet line, shit you use in the shower. Personal care products and ancillary beauty products. Now, again, what was memorialized in the corporate documents, and that's why this wasn't attached to the other lawsuit, I suspect, because what's memorialized in the corporate documents doesn't say this. But these meeting notes are kind of the basis of Clark's arguments in the other lawsuits, which is interesting. It says, though, is the solely exclusive brand of Miss Tati Westbrook. Beauty industry product lines include. Is that speaking about the beauty industry in general? Or is that speaking about what Halo should include? Because the way it's written is going to be picked apart if this even comes up, because it's not best evidence of the agreement. But it's interesting to me that this is where we actually see, and the only place we've actually seen, it talked about that this was to be, that Halo was to be the exclusive brand of Tati. Not exclusive like Chanel's exclusive, but like the all-encompassing brand. Because that's not what we see when we get to the corporate documents. So let's get to the corporate documents next. We're scrolling. There's like an entire transcript of the... Oh, the other thing this said, I asked about this otherwise, and it says very clearly at the top where the meeting took place. It lasted an hour and 40 minutes and was documented by audio recording as agreed upon by the members, which we asked about. I said, do they all agree on recording it? Yes, it's in the minutes. Apparently in 2017, they agreed. Yay! things that happened. All right. I am looking, the corporate document should be the next exhibit. So we're all just gonna scroll together and be like, winner, winner, chicken dinner, and then we'll go back to the declaration. The declaration. There's also an objection to the there's evidentiary objections to this. All right, this is emails. We don't know what the emails. Action by unanimous meeting. This is what we wanted. But where is it? No. There is a part of the meeting where they the minutes and the notes where they talk about changing over the company and what this is not it, because this is probably the bylaws, and that's why. Written consent in lieu of organizational meeting. These are the resolutions, but this does not clearly state that it's going to be the sole exclusive brand, and this does not state what it will be. And the next one that was attached to the lawsuit, was it the bylaws, that talks about what they are allowed to do or not allowed to do, doesn't again talk about it being exclusive. It says that each member is allowed to do things as long as it doesn't diminish the time spent with Halo, as long as it doesn't compete directly with Halo. And that's the only part that was really put into the California lawsuit, because that's the overriding part, but nowhere in that, and these were again drafted by Swanson, nowhere in that does it say sole exclusive brand. So from the time they had the meeting to the time these got drafted, the understanding either moved or it didn't get memorialized into the official documents. Because this says, each of the members, this was what I was looking for, the outside business activities. Each of the members of the board of directors and officers of the corporation may not engage in any other business activities that, one, materially interferes with their services to the corporation. So pulls them away from spending time with Halo, materially interferes. Two, competes with the nutraceuticals line of the corporation. The Westbrooks are going to argue makeup doesn't compete. Clark's going to argue makeup was always supposed to be in here. Where's 3? 1, 2. There's no 3. Okay. And I wonder if 3 got pulled out. And or 4, any personal investment activities in enterprises that directly compete with the corporation or with Halo. And there will be some argument, I'm sure, that Clark's other involvements in like Flavor Cure and the other stuff are nutraceuticals or are vitamins or are supplements that might compete. It's reserved that Clark Swanson may continue to own his interest in Renzian as long as its products don't compete with the products manufactured by Halo. It's further resolved that Tati and James may continue to engage their services to each of Tati Inc. and Takes a Team Productions in connection with the development, production, and distribution of content on YouTube and on any other platforms not known or hereafter devised, like TikTok was not around in 2017. 2, in the exploration of any and all rights in connection therewith. And the Westbrooks will argue that, okay, well, having other lines of stuff is in connection with the YouTube channel. And Clark's arguing, no, the minutes from the meeting said it should be the exclusive company. So we're going to control F ourselves real quick, and we're going to control F over to Clark Swanson's declaration. And then I'm going to go to questions. Thank you, mods, for hanging in there. Eventually we'll get back to just a 2-hour stream. So let's find this declaration real quick without me having to scroll everywhere. I know this new keyboard is so loud. I have another one coming that's not as loud, but this one is super freaking loud. All right. It's only a few pages. Declaration of Clark Swanson in connection with the objection to the TRO, which was granted kind of in halvesies in part. Declarations under penalty of perjury. In the fall of 2016, my longtime friend, this reiterates a lot of what's in the LA lawsuit because they're arguing about the same shit in 3 different places. In the fall of 2016, my longtime friend James Westbrook and James's then girlfriend Tatiana Westbrook and I decided to develop a nutraceuticals product. There it is. Tati offered that she could market the product on YouTube. After discussions among ourselves, we formed a company named Inside Out Beauty Labs. On March 6, 2017, Inside Out Beauty Labs filed their use of trademark Beauty Booster with the USPTO. That's attached. I owned 50% of the business, was the managing member. James and Tati, sometimes referred collectively as the Westbrooks, each owned 25%. See minutes of special meeting held, which identifies the original ownership structure. A true and correct copy is attached. My education, training, and experience were critical to Inside Out Beauty Labs. The Westbrooks did not have any, this is all from the LA suit, did not have any commercial credit relationships, so I used my banking relationships. The Westbrooks' poor credit history, including a personal bankruptcy, meant Inside Out Beauty Labs relied on my personal credit to secure lending and e-commerce facilities. More important than logistics, I researched and developed the products that they were planning to launch. Those would be the nutraceuticals. We've killed the water. This is why I bring two. After years of research and development, I identified unique or exotic ingredients and negotiated supply agreements, did things for the Creamicide RX. This is all in the other lawsuit. On July 17th, the Westbrooks and I agreed on the name Halo Beauty Nutraceuticals LLC for the company. It ended up being under something else. James agreed and emailed the company legal counsel requesting that they make the name change from California company Inside Out Beauty LLC to Halo Beauty Nutraceuticals LLC. The company then established a trademark for Halo Beauty NTX. However, before the name change was accomplished on August 1st, 2017, James called me and asked if the three of them could meet. The three of us could meet. The three of them could meet in person. Well, he's included, so three of us could meet. Later that day, the Westbrooks visited me at my home in Marina del Rey. There's a footnote. This conversation was, with all parties' knowledge and consent, recorded, which is one of the reasons why I'm able to recall the events with specificity. A true and correct copy of the transcript of the meetings attached as Exhibit D. The three of us spoke for about 2 hours. Well, no, it says in the other motion, an hour and a half. With specificity. I'm teasing. Just teasing. The Westbrooks asked to re-envision Halo Beauty as a new company that planned to be a global, all-inclusive beauty brand. The plan was to use see Exhibit D. Again, those are notes. That's not what was memorialized in the corporate documents. The plan was to use Halo Beauty to deliver a wide range of beauty products. Tati claimed she wanted to build something gigantic. This is all in the other lawsuit. Specifically, Tati stated to me that, one, she wanted to build her brand under one umbrella rather than just do vitamins. She wanted to expand Halo to include a wet line, cosmetics, and skincare. Halo had the potential to expand to become a huge standalone brand. That's all in the other lawsuit. In an effort to get me to relinquish 50% ownership, again, that's an assumption of what they think. But either way, speculation lacks foundation. But either way, this is all in the LA lawsuit as well. In an effort to get me to relinquish the 50% I was holding, the Westbrooks sold me aggressively on the financial benefits of the new all-inclusive brand. See Exhibit D. E-commerce-based beauty businesses were being acquired by major beauty brands like Estee Lauder and L'Oreal for eye-popping amounts. For example, Tati identified Jeffree Star, a potential advisor, and stated that he had been offered $500 million for his brand from L'Oreal. James stated he thought the company could reach a $3 billion valuation. Tati boasted her celebrity status would guarantee success. This is all in the other lawsuit. Quote, I know as far as our repeat customer, it doesn't matter. What I put my name on is going to work. It's going to sell, period. Because of the 7 years I put into building an audience. She claims that the product didn't matter. She could still sell a shit product to her loyal followers. That's all in the LA lawsuit. We're going to put it in everywhere we can. Tati, who by that point was well regarded, also touted her clique of fellow influencers and as a potential source of promotion. Again, Jeffree Star, Manny MUA, James Charles, and Laura Lee. My, how time has changed. This was in 2017, remember? According to Tati, those YouTube influencers would look for Tati to endorse their products, which she would. She in turn would expect them to give endorsements to Tati's products. Tati related that she was sitting in her dining room with Laura, Manny, this is all in the other one. James and Jeffrey, when Jeffrey disclosed that a nutraceutical competitor, Sugar Bear Hair, was offering him $200,000 for a promotional video. Tati told me she asked these influencers not to endorse Sugar Bear Hair because she was launching a competing one. She told me these influencers turned down the Sugar Bear Hair offer. After an extensive pitch by the Westbrooks and in exchange for Halo Beauty becoming Tati's exclusive channel for all things beauty, I gave up my 50% stake for a third. Then it gets into the email. Great. Again, these all memorialize the notes, but the corporate documents say what they say. The understanding was memorialized in the meeting, the meeting minutes, as well as the articles of incorporation. The thing is, the meeting minutes and the articles of incorporation don't say the same thing. The articles of incorporation say a fraction of what's in the minutes or what's in the incorporation and the bylaws. The meeting minutes aren't best evidence of what was decided. The formal documents, the articles of incorporation and the bylaws are what going to matter. And it's, I think, going to be instructed to the court that Swanson wrote the minutes and Swanson wrote the articles of incorporation. Nobody left it out or cut it out, but this is going to be a lot of fighting over the minutes said this, but the minutes aren't the best evidence. What was memorialized in the corporate documents are the best evidence. And that is going to be fought back and forth and back and forth and back and forth. And the minutes, again, the minutes can't be, once you get down to it, the minutes aren't going to be able to be used. What's in the documents matters. One of the important agreements, which was also memorialized in the bylaws, was the agreement that all major decisions would be made by unanimous consent. This gets to the fact that he doesn't believe he can be yeeted as the CFO because of unanimous consent, and he obviously did not unanimously consent to yeet himself from the CFO position. The agreement that all major decisions would be made via unanimous consent was not only confirmed by the parties' conduct, but was specifically confirmed in writing by James on multiple occasions. For example, on October 9th, 2020, James emailed me stating, among other things, the fragrance deal was never signed because you blocked it. A true and correct copy of Westbrook's October 9th, 2020 email is attached. And it seems that went down, that there was going to be a fragrance at some point, and Swanson said, no, we're not doing a fragrance. Why that happened, we will get into another day, because there's a lot more documents that has come out and everything that Swanson has submitted to the court. And we still have a motion to dismiss. And we don't even have Tati's side of the motion to dismiss in this case yet. And we still have a motion to dismiss pending in the LA case. On or about May 23rd, 2019, Halo reorganized as a Nevada corporation. Halo Beauty Partners was formed at the same time and intended to be structured the same as the parties discussed back in 2017. The intent was to transfer the assets of Halo Beauty Inc. to Halo Beauty Partners, although ultimately that never happened for a variety of reasons. The parties intended Halo Beauty Partners to conduct its corporate affairs in the same manner as Halo Beauty Inc. and set forth in the articles of incorporation and bylaws. He's saying, however, James never provided Halo Beauty Partners' attorney with the information needed for the creation of a formal operating agreement. With the new business plan in place, I went to work on an all-inclusive brand with respect to the first product line, Beauty Vitamins. I applied my knowledge of plant-based medicine and nutritional science and formulation. This is all in the first one. Consumers found the results for the Halo Beauty Skin Hair Nails formula provided such visual, measurable results for troubled skin conditions such as acne and other dermatosis that the patent work reflected the unique, beneficial, and novel outcome. Novel outcome. They work. Is that the novel outcome? Supplements work. It's so novel. Okay. My contributions to product formulations ensured that the customers of Halo Beauty saw results, causing significant reoccurring sales. March 2nd, 2018, Halo Beauty launched its first product, hair, skin, and nail boosters. Okay. Back on February 27th, Tati launched a teaser video. This is all in the LA lawsuit about Tati talking about the brand, my brand announcement, all the things. Those videos I think are still up. On March 2nd, 2018, Tati posted a video, "Get ready with me, Halo Beauty launch day." And on that video, she stated that Halo would be launching other products and that Halo would be keeping Halo a good and pure inclusive brand. Again, Lawyers are going to argue whether inclusive means inclusive of all peoples or inclusive of all products. Like, what is the meaning of the word is? And they are going to fight about it. The Halo launch was a fantastic success. They followed with the Nail Booster and the Kiwi Seed Booster, His and Hers, then His and Hers Daily Multi-Body and Brain Boosters. In the first year, Halo earned its owners over $1 million each in distributions. That includes Swanson. Halo currently offers 3 different product lines, including His and Her multivitamins. And in 2019, the company distributed almost 3 times what it distributed in 2018. So it distributed over $9 million to the 3. So almost $3 million each. Well, I applied myself to expanding the Halo Beauty brand. The Westbrooks would not cooperate, he says. Coming off the success of the vitamin launch, I devoted my efforts to develop the skincare and cosmetic lines. The Westbrooks contemplated when they formed Halo Beauty Partners. I went on multiple on-site visits to manufacturers. For example, I connected with Nicole Collins, an experienced cosmetics and skincare entrepreneur. She offered to introduce me to leading branch chemists and manufacturers, including Seed Beauty. But Seed Beauty was going to launch the perfume, and that was blocked by him. So the timing of that's going to be interesting. Beginning in May 2018, I began taking meetings to explore skincare and cosmetics. I joined Collins at tours of several cosmetic and skincare facilities. I continued to meet separately with other manufacturers. I kept Tati and James apprised. On July 6, 2018, I sent James a text message that read, "When are we making a makeup line? I thought we were doing ingestibles, then skincare, then cosmetics." Tati mentioned in her video last week regarding it being a ways off. See text message, a true and correct copy. Well, we don't know. There's probably not foundation for that. I attended Cosmo Proof in August 2018, a beauty exhibition where I met with several makeup-capable manufacturers. As late as November 5th, 2018, I attended a meeting with Cosmetic Development Laboratories, an established manufacturer of cleansers, serums, moisturizers, masks, and other skincare. This is all in the other lawsuit. All of it. In spite of significant efforts and good progress to show for it, the Westbrooks never showed any interest in these meetings or my work to expand Halo. Other times, the Westbrooks actively interfered with my efforts. Nonetheless, I continued to push to expand. However, the Westbrooks' response shifted from ignoring my efforts to actively interfering with Halo Beauty's business. In September 2018, I was asked by a renowned YouTube influencer, Michelle Phan, to join her for lunch to discuss prospective business in China. Phan is an American makeup artist, entrepreneur, and voice actress who became notable YouTuber, pioneering beauty YouTube. Phan's YouTube channel has over 8.9 million subs, 1.1 billion lifetime views, 385 uploads. This is all in the other lawsuit. None of this is relevant, by the way, to the TRO. Like, legit, none of it. None of it. None of this is relevant to the TRO. All of this is him wanting to re-litigate the LA stuff and rehashing the LA stuff. She is the founder and owner. Yeah, she's great. Yay, Michelle Phan. Michelle Phan's fantastic. Okay. She's the founder and owner of cosmetic lines EM Cosmetics. In 2015, she was named 30 under 30 in Forbes 30 under 30. The same year, she raised $100 million to value the company Ipsy at over $500 million. She's actually part of the Avenatti litigation because he was one of the, well, it's alleged that he did not pay her for the sale of Ipsy. So there's an interesting little Michelle Phan, Michael Avenatti connection because YouTube is everywhere. When the Westbrooks learned about the meeting, they insisted I cancel it, telling me on the phone, "I demand you stand down." Stand down! We went over this all in the other lawsuit. James told me I was forbidden from making relationships with influencers. Tati claimed to be working on a project with Phan. At their insistence, I canceled the meeting. The next month in October, I emailed the Westbrooks regarding updates, cosmetics, hair care, Michelle Phan. Tati informed me that our focus needed to be on additional products in the supplements category. She was not considering the offer made by Borgio Hair Care. This is all in the other lawsuit. Finally, in the build-up to the launch of Tati Beauty, James actively deceived me into thinking he and Tati were still interested in launching cosmetics with Halo. On December 16th, I asked James again to go to Cosmetic Enterprises. I underscored that Cosmetic Enterprises was a trustworthy manufacturer for skincare that could also provide introductions for makeup chemists and manufacturers. James declined.
stating really bad week for a field trip, bro. And I'd prefer if you not do this alone. I can't emphasize this enough. Tati needs to take the lead on this. Please pull back. I feel you and I love your enthusiasm, but this isn't a ball for you to carry. To which I replied, no worries. All of this is in the other lawsuit. All of this is in the other lawsuit. So this is them going back and forth again. None of this is relevant to this TRO. He's saying, look, there shouldn't be a TRO because the facts are in dispute, but all of this is in the other lawsuit. On or about October 25th, 2019, Tati Beauty. Why is my husband outside? I don't know what he's doing. Tati Beauty launched its first product on October 29th, 2019. The Westbrooks announced that Tati Beauty had sold out of the 100,000 of 250,000 total units in the initial run. The company took pre-orders for a second printing. To present, I estimate that Tati Beauty's revenues to be in excess of 16 million. Gross revenues, not net revenues. Disappointed by the launch of Tati Beauty, I continued to push for Halo Beauty skincare line around August 4th, 2019. After continued prompting, Halo Beauty hired Benchmark Cosmetic Laboratories to formulate a number of products, beginning with a makeup setting spray and makeup primer. The products were designed with ingredients identified from Halo Beauty supplements, and also improve the look of cosmetics. The Westbrooks refused to cooperate in the process and interfered with the opportunity. Benchmark sent samples to the Westbrooks for a wear test around February 9th, 2020. James suggested a few minor modifications to the formula. Benchmark agreed and sent new samples. The Westbrooks delayed for months and ultimately refused to provide any further response. To date, the Westbrooks have not approved the launch of the makeup setting spray. No new product launches are planned. Well, yeah, after February, I guess it was a fairly long go between February and the October lawsuit, but then they started getting into talks of lawsuits. On or about June 2019, the Westbrooks unilaterally hired Kate Barnett, and this is in the motion for the TRO with regard to the two employees. The two employees of Halo were submitted declarations saying that they work for Halo and nobody else does, because it's alleged in there that Swanson's mother-in-law and father-in-law are on payroll but don't work for the company, but we're getting health benefits. So that's why this is coming up. This actually does pertain to what's in the TRO, helpfully. 10 pages in. The Westbrooks unilaterally hired Kate Barnett to work for Halo Beauty and Customer Service. Barnett was Halo Beauty's first employee. At the time, its only employee. Barnett was not hired because she had anything of value to contribute to Halo. Ouch. But solely because she was the best friend of Tati's sister. She was not hired because she had anything of value to contribute. Yikes. Notwithstanding her lack of experience, in October 2019, the Westbrooks caused Halo Beauty to change her pay grade from an hourly consulting arrangement of the sum of $25 an hour by naming her the director of customer support and paying her $100,000 per year plus health benefits plus a $10,000 moving allowance. I wonder if she moved to Nevada, because it seems like they live in Nevada. Okay, let's just put all the company secrets on blast. Let's just put all of the company, all the shit's on the street, and you can't put it back on the horse. All the shit's out there. A while later, James hired another employee named Megan Carter. James told me that Megan worked for a competitor to Halo Beauty, Tati Beauty. She was, in reality, an employee of Seed Beauty, the proprietor of the Westbrooks cosmetic line in connection with Halo Beauty. I expressed my concern in poaching an employee of Seed Beauty, given the relationship with Tati Beauty and what liability may exist for Halo if Carter was hired. James assured me, all of this is hearsay, but okay. James assured me that the ownership of Seed Beauty was fine with the arrangement, and the Westbrooks attempted to promote a shared services agreement with me, whereby Carter would work part-time for Tati Beauty and part-time for Halo Beauty. She would be remunerated as director of social media for $72,000 a year plus full benefits. I stated that hours could not reasonably be accounted for, and he was concerned disproportionate time. I stated that hours could not reasonably be accounted for, and that he was concerned disproportionate time would be spent on Tati's projects and not Halo Beauty. He who? Is Swanson referring to himself in the third person in the middle of this sentence? Ultimately, Carter was hired as Halo Beauty's second full-time W-2 employee.
On June 2020, my in-laws, Heinz and Edith Fisher, the Fishers, had moved to and were living in Nevada. James suggested to me, note, James' declaration says he has no knowledge that these people were ever hired. James suggested to me that they be hired by Halo in order to assuage some of my concerns over the other two employees. Accordingly, Halo hired the Fishers as employees to pay them the sum of $8.50 per hour plus health. James suggested the hiring as a way to equalize the cash costs going to Tati's family friend, Barnett, who was accumulating $60,000 above her normal pay grade. James suggested to me that he increase the Fisher's salary because Halo Beauty doesn't pay minimum wage. I conceded, and their salary was raised to $10 an hour. That's like the diametric opposite of what is in James's declaration. James's declaration is like, why are these people on our payroll? We never approved it. We had no knowledge. This case is such a mess. Like, it's such a mess. It's just like, nuh-uh, yaha, nuh-uh, yaha, nuh-uh, yaha. I want to see the documents where the Westbrooks signed off on this. Thus, contrary to James's false representations to the court about discovering Halo Beauty's hirings of the Fishers later, he actually directed that it be done and that their salary be increased. Further, as a small company, James knew and should have known that he had open access to any of the service providers to Halo and what Halo Beauty was paying them. I certainly never refused James' request for payroll information. Contrary to James claiming he did not have access to the corporate American Express card, alleging that it was part of a scheme to hide payments. Well, why would you pay the healthcare not through payroll and through a credit card? But okay. Not only did James and Tati have access to the American Express card portal, James was a regular user of the card, for which both he and Tati held individually. See email attached. In spite of the ongoing business disruptions, I've continued to devote my efforts to the success of Halo. The Westbrooks, however, moved on from Halo Beauty and Tati Beauty in violation of their agreement with me. This is the other stuff. Just months after the launch of Tati Beauty in October, James told me not to promote Halo Beauty sales for the rest of the year, claiming Halo could just coast for the rest of the year. In fact, the Westbrooks spent their time and energy promoting Tati Beauty and ignoring Halo, which, if true, would be a violation of the agreement because the agreement says you cannot do business ventures that pull your attention away from Halo. That's actually in the agreement. The rest of this is like, which is going to take a jury to parse out. Or a lot of mediation. This left Halo with no choice but to coast. In 2020, the Westbrooks continued to cut Halo Beauty out of future opportunities, and the Westbrooks are alleging that he never formulated the things on time and didn't pay the sales taxes and all this other stuff. It's just like so much stuff. In late February, James told me that the Westbrooks, spurred on by their new talent agency, UTA, would launch a fragrance product in collaboration with a New York-based marketing and manufacturing firm. According to James, this was Tati's idea because she wanted to do something on her own without her husband or me. I can imagine Tati being like, fuck you, fuck you, fuck you. By February 2020, I'm out. I want to deal with none of y'all because this is already going like this by that time. Again, like he did with the cosmetics, James claimed that this would not detract from Halo's business, and the Westbrooks were committed to Halo Beauty. To support the claim, James told me that Tati had very little to do with the creation and launch of Tati Beauty, that the agreement with Seed Beauty, he said, was turnkey, with Seed Beauty handling all the formulas, manufacturing, social media, and commercial agreements. This, of course, directly contradicted Tati's statements on a YouTube video. So it's just like, see, in YouTube, she said she was hands-on, and here she's saying she's not hands-on. In her YouTube video touting her deep involvement in the Tati Beauty product, I reminded James that a fragrance line was already contemplated for Halo as early as April 25th, 2018. I emailed James regarding the Kardashians' fragrance product and packaging and noted the high margins in the business line. Yeah, fragrance makes bank, folks. You want to know why Britney Spears has so many fragrances? Fragrance makes bank. I don't know why that's underlined, but okay. On March 13th, 2020, I emailed James about the fragrance line and spelled it out. Tati Fragrance is a product line that we contemplated when we formed Halo. And again, when I gave you and Tati the controlling interest in the business, even if you are right that Tati Fragrance could be good for Halo, there's no way it's better for Halo than having Halo own and operate the fragrance piece of the business. As an officer, member, owner of Halo, I don't think that any of us can, in good faith, claim that any other course of action would be in the best interest of Halo. Reconsider in light of Tati and your obligations to Halo. According to James, Tati decided against a fragrance product because of my opposition. I mean, or like it said earlier in this, it said that there's an email from James saying we didn't do fragrance because you blocked it. So did Tati pull support or did Clark block it? Because this document says two different things. This is longer than anticipated because it relitigates the entire other lawsuit. Plus the new stuff. Even though I was tasked with dealing with the financial matters for Halo, James frequently interfered with my attempts to appropriately deal with company finances. Even though James would then disappear for days and weeks with no contact with Halo's employees. For example, James would contact vendors on home or personal phones from 7 p.m. to 11 p.m. or later and publicly humiliate vendors. What? I mean, now we're just like saying stuff. I would then have to try to mend the business relationship between the vendors and Halo Beauty. Okay. And they're alleging that Clark used his personal email and not the business email. It's such a mess, you guys. This is such a mess. Look, in law school, they said partnerships are the only ships that never sail. We're going to have a whole case study out of this case on partnerships. And this is just like, again, lawsuits being allegations and shade. This is like, and you suck. Like, let's sprinkle in you suck. Okay, it's been a few paragraphs. Let's not forget to sprinkle in how much I think you suck. Even though the CFO and CEO would typically sign tax returns, James would instruct his personal accountant to prepare tax returns for Halo Beauty early, and he would sign them without consulting me or allowing me to see the returns before they were filed. That doesn't make any sense. James' accountant, Semaphore, also cost Halo Beauty additional taxes by improperly allocating the salaries of the owners on at least one instance. Further, James was the only person with access to Shopify admin tools and able to administer sales tax collections. It wasn't my fault about the sales tax. It was your fault about the sales tax. Nonetheless, errors were made on sales tax remittance. James also hired a third-party firm to assist with collecting sales taxes, but apparently instructed the firm not to communicate with me. James has instructed other vendors to do the same. I tried calling and emailing the manager of Halo Beauty's account, Joe Rasmussen. That's just fun to say. Hopefully we get to say it more. Rasmussen would not respond. During the same period, James was in constant contact with Rasmussen. I believe that the only reason why Rasmussen did not return any of my calls or emails was at the direct and specific instruction of James. Well, you don't have personal knowledge of that. That's just a thought. Thus, I had no ability to assist in the sales tax. Moreover, this is not an objection to a TRO. This is an objection to the complaint, but that should be the response to the complaint, not an objection to the TRO. It's like, no, I'm going to say everything. Mention it all. Oh my God. Moreover, from the outset, the parties intended to find an office location in the state of Nevada. However, they were never able to agree because the Westbrooks wanted a 3,000 to 6,000 square foot facility at a time when Halo only had 2 employees and was just starting up. James demanded I find something that would have space for 20 people, even though Halo was just starting up. I went to try to find a suitable space in Las Vegas while the Westbrooks took off to Seattle. What date was this? Well, the Westbrooks took off to Seattle and showed no intent of moving to Las Vegas to work with Halo. In the spring of 2000, okay, that can't be right. We've gone back in time. In the spring of 2000, I found a suitable space, and James demanded I lease the space. On March 9th, I submitted the LOI to rent the space. However, I had concerns with leasing property during COVID, and no lease was ever agreed upon, which saved Halo Beauty hundreds of thousands. On August 30th, 2020, I sent a letter via legal counsel to the Westbrooks demanding that they honor their agreement with me. Okay, so the Westbrooks took off to Seattle. He says in here the Westbrooks took off to Seattle prior to him in August saying, yo, I'm going to sue you if you don't deal with me. And then filed a lawsuit saying that he knew that the Westbrooks lived in LA. But in this, he's like, man, they just took off to Seattle and didn't give a fuck. Then you can't file under penalty of perjury that they live in LA in the other lawsuit. There's too many contradictions. It's just like the tit for tat. This is the demand letter, which is now attached as Exhibit L. The demand letter, by the way, the demand letter and all of its exhibits are attached to this, which is why it's like 400 pages. The demand letter that Swanson wanted, or Swanson's counsel, asked me to take down off my channel for talking about is now filed as an exhibit in 2 lawsuits. So it's now a publicly available document in 2 lawsuits. But okay. It's in this one too. After it became clear to me that the Westbrooks had no intention of living up to their agreement, I was left with no choice but to file a lawsuit against the Westbrooks. And on October 20, 2020, I did. We sued them. And I told the court in California that they lived in California. And that's why there was jurisdiction in California. However, I also say in this that I'm swearing under penalty of perjury that they yeeted themselves to Seattle before I sued them. Therefore, I knew they yeeted themselves to Seattle, but I still told the court in California that it belonged in California because they lived there, but they had taken off to Seattle. Okay. Sure. On October 30, 2020, only 10 days after I filed the complaint in California, the Westbrooks sued YouTube personality KJ Paulson for defaming them. See case. This is now referred to as the Paulson lawsuit. Oh boy. I didn't know we were getting into this today. Great. Of course, because what he's trying to file is not an objection to the TRO. What he's filing is a declaration that word vomits every response to the entire second amended complaint, which is not an objection to the TRO. But okay. Let's just continue. Then we're getting to questions. The Paulson lawsuit was filed 2 days after Paulson uploaded a video to YouTube titled, I Was Right About Everything, a huge story coming on Tati Westbrook, and alleges that Miss Paulson devoted numerous hours of content on YouTube and numerous Twitter posts to discussing the Los Angeles complaint. The Paulson lawsuit was ultimately dismissed for lack of personal jurisdiction on March 15, 2021. Contrary to the Westbrooks' false accusations and assumptions, I did not furnish anything secretly to Paulson. Was it very upfront? Who likely obtained any information on the Westbrooks from public information in relation to the California lawsuit or matters posted on YouTube by Tati herself. A declaration is included in the Paulson lawsuit with exhibits that include all correspondence with Paulson directly refuting the Westbrooks' claim. A declaration is included in the Paulson lawsuit with exhibits that include all correspondence with Paulson. What? I don't know what this is referencing. A declaration is included in the Paulson lawsuit with exhibits that include all correspondence with Paulson. With Paulson and who? Herself? Hold on. Because where is it? See, we're just going to the paper. Look, in the letter I was sent, it said, hold on. In addition, you should be aware that your statement that Mr. Swanson was feeding information to drama channels to undermine the Westbrooks. No, I said that's what the lawsuit was alleging. But anyway, equally false is the Westbrooks allegation. Okay, all communications that occurred between Mr. Swanson and Miss Paulson occurred between August 2020 and October 2020, long after Paulson's videos. Well, no, August is before this and long after some of the videos. At no time between August 2020 and October 2020, nor any other time did Swanson provide to Paulson or any other drama channel any disparaging or defamatory information about the Westbrooks. Well, the information he provided might have been used to disparage and defame. But he admits, his counsel admits, that they had communications. So is this trying to indicate that he didn't have communications? Because, like, it's already been made clear that there were communications. Like, what? What? What is happening? Okay. I mean, I think it's worded very carefully to say, I did not furnish anything secretly to Paulson. Okay, well, secretly is a modifier. And they're saying who likely. This is a guess. Because you know what KJ said in her video? That you provided her the information. Her video says, my source was Swanson. Okay. We're going to move on from that point. I don't know what declaration they're referring to because it doesn't make sense. Because I don't know what declaration they're talking about. On or about June 18th, 2021, I was forced to file a They made me do it. I was forced to file a defamation action against the Westbrooks for other events not referenced in this case, but relating to the Paulson lawsuit with the Superior Court of Washington. See, we've covered that lawsuit. That's this one. That's this one. In what is clearly a retaliatory action on or about July 8th, the Westbrooks exercised the corporate muscle that they had defrauded me out of by using their 66% ownership in Halo to execute a written consent, purportedly removing me as director and CFO of Halo Beauty. This action violated the agreements that the Westbrooks and I have lived by since the company was formed. Okay, but this is not related to the TRO. None of this is related to the TRO. At the same time, the Westbrooks allegedly removed me as director and CFO. The Westbrooks cut off my access to company books and records. We know that from their filing. This lawsuit filed by the Westbrooks is retaliation against me. This is all a reply. Like, this is all a reply. This is all a reply. This has nothing to do with the TRO. This is just like, look, Your Honor, look, there's so much in dispute. You can't make me do the things. Because generally a TRO is not appropriate where a lot's in dispute because it has to be sorted out. There has to be an evidentiary hearing, and that can take ages because you can see why. But the TRO in this case was just like, hey, we need access to our books and shit. But this much word vomit is like, look, Your Honor, there's too much for you to do it. It didn't work because the court was like, no, we're going to just make you turn over the books and stuff. This lawsuit was filed in retaliation. This is all an answer, but okay. Now we know what Clark's position of the case is. This is retaliation. They're big mad. It's clear that the Westbrooks are big mad. It's clear that the Westbrooks are seeking an injunction in an effort. This is all argumentative. To prevent me from having access to the books and records of Halo, thus allowing the Westbrooks to further loot the company and pay their personal attorney's fees without any oversight. There it is. They're looting the company. This is what he is alleging in just all of this. Even worse, the requested injunction would prohibit me from pursuing the claims asserted in the California lawsuit. How? Because you would have all that stuff in discovery. And the California lawsuit is not over stuff now. It's over past. Discovery would fix that. No, it wouldn't. Actually, no. In the California lawsuit, I'm seeking damages in excess of $50 million. Specifically, I'm entitled to 1/3 the value of Tati Beauty. What's the value of Tati Beauty after one launch and nothing else being launched and a pandemic? I wonder. Mr. Westbrook estimated pre-launch that the company would be worth 50 to 100 million in a sale. Okay, well, the world has changed. Cross-checks of recent sales of similar businesses show this estimate's reasonable. Similar businesses have sold for multiples ranging from 5 to 12 times a company's revenue. If you sell Tati Beauty and Tati is no longer a part of it, what does Tati Beauty become? What is it worth? Let me know in the chat. How much is Tati Beauty worth without Tati? Because these are personality-driven products. Assuming Tati Beauty's revenue is 16 million, a reasonable valuation would be between 80 and 192 million. I want to know how that math works. Halo Beauty should be entitled to all of the Westbrook's share of the business, and I, as 1/3 owner of Halo Beauty, would be entitled to 1/3 of the value, 26.66 to 64 million. I make this declaration freely and of my own will and choice, and I declare under penalty and perjury that everything I say is true as I see it. Then there's more. We will summarize the more in another day because you have questions, I have questions, and we've been talking for 2.5 hours. So we should just do some of those. And I should catch up on some of the super chats I missed. Thank you for your support. And you should subscribe because we're almost at 150. Maybe I'll just keep talking till we hit it. No, I'm teasing. I'm not going to do that. Questions. We have, holy shit. That was so not on point and wandering. But that all felt to me like Clark was like, I am going to be heard. I am going to be heard and you are going to hear me. And this is what they did. Westbrook's bad. And again, I can see based on the meeting minutes that is the part that he's like, the meeting minutes say this, but the corporate documents don't. So all of you are giving me your valuation of what Tati Beauty would be worth without Tati. I feel like if KVD was way more established brand, so I'm unsure if that's a good comparison. It was, and KVD got kind of controversial and people liked the brand. Tati Beauty had one launch of one product. So without Tati, what is Tati worth? It was one launch of one product. So, yep. And this, yes, you guys are making the point I was making. I think the brand probably survived without KVD, but it's the same, maybe it would be the same now for Jeffree Star Cosmetics. Would Jeffree Star Cosmetics do better without Jeffree Star attached to it? Because people like the formulas, but don't like him. I don't know. And don't like him, I realize is an estimate, is an understatement, is a significant understatement. All right. Let me thank all those who super chatted. Dr. Riley, I was trying to think of a brand where the prominent person left and the brand kind of went blah. I mean, I'm sure there are plenty, but the personal brands of influencers tend to, if the influencers step away, tend to fizzle. You guys, there are over 3,000 of you watching. We are almost at 150K. I'm sure not all of you of the 3,000 watching, I appreciate you, are subscribed. So don't forget to go ahead and do that and subscribe and, do the likey things on the video. I don't know how many likes we're at. I need to go get my whiskey bottle, but I can't because then I might spill it on my keyboard and break another keyboard. If you want to know about how I wrecked my keyboard with whiskey, you're going to have to listen to the Emily Show because that's where I talk about it this week. And the audio episode comes out tomorrow. It's Tuesday, right? Yes, it comes out tomorrow. All right, let's get to our super chats. Thank you so much. I appreciate you. I'm going to get them as fast as I can. Have there been any H3 Triller updates? I have done an update because they added Gila and Teddy Fresh and everybody to the complaint. So I did that update. It's on that playlist. Nobody said if Josh's case is tossed out due to HSA apps, how does that affect other cases? Well, they would have to make the same motions. Also, can't cops ask to see your phone anytime, like traffic stops? Stop and frisks are one thing, but generally you have the right to say no. You have the right to say, no, you can't see my phone. And in this case, they did ask and they did say yes, but you have the right to say no, and you aren't, without a warrant, you can't be required to provide your security code either, which should always be on. So, Questions. Josh said he wanted to call his lawyer. They took his phone. Must cops let you call your lawyer immediately? If not, how long? Cops do not have to immediately let you call your lawyer. They just can't question you. They can say, yeah, we'll get to it, and then just not ask you questions. But that has to be invoked during questioning. So yes, they took his phone because it was part of the search warrant. And yeah, so no, they don't have to let you call your lawyer immediately. They can say, yeah, we'll get to that. Normally, you won't be allowed to call or connect with your attorney until after you're arrested, booked, or they're done with their investigation. But they can't question you. Cami282 said, how much is this defense costing? A lot. Josh's dad is paying, I don't know. Meanwhile, his daughter Jill said he refused to help with her emergency C-section and NICU bill. That's a bummer. I had an emergency C-section and a NICU baby who was in the NICU for a month, and that shit is very expensive. So I don't know. I don't follow the Duggar family dynamics. I don't follow content on the Duggar family dynamics. I'm just following this case. So I don't know. But yes, I imagine. I don't know who's paying for it. I imagine it is not inexpensive. A lot. And this is not shade. Like, I will shade Dad Spears' lawyers' bills all day long, not them as individuals. They're doing their job. But with regard to these lawyers, they've done a good job. They have put in the work to make motions that make sense, and even some novel motions that still make sense. So the defense is doing its work. But it is not going to come inexpensive, because they have put in a lot of work into these motions. And the government puts in that much work into their motions too, but the government's being paid by all of us. So they are kind of free from billable hours and such. They just get to do the work they do. Kathy says, I bet they want his hands and feet photos because he is in some of the photos, videos, or to rule him out producing it. This isn't, Kathy, I appreciate the thought. This isn't a production case. This is just a possession case. So this is not a production case. These are known files that float around the internet, and this is having those known files. These were long ago produced. So this is known. So Samantha Dorr said, in regards to the hands, is it possible while looking at footage they could match the hands? If they were trying to do that, Samantha, they would have to get a warrant for that, because they would actually be seeking evidence. But there's no charge of production here. That's not what's contemplated. This is just having the thing. So Carla, thank you for the super sticker. Amber said, hands and feet are often used to identify adults in the videos. That's not being alleged here. Not watching the videos, the adults committing the acts, and that's not alleged here. Susie, I really do think what we'll see the government's response. I think this is our standard booking procedure to show nobody was handcuffed too tight. Nobody fought back with anything. Like, there was no injury on the hands. But we'll see. Susie Q said, it was reported that Tom Girardi moved into a retirement home. I talked about that at the top of the stream. I know how expensive these are. It's estimated that one is like $5,000 a month. If he doesn't have long-term care policy, where in the world is that money coming from? Likely his brother or other family members would be my guess. G Dash said, does watching your law breakdowns about Duggar enough stop someone from serving on a jury? Same thing for Jen Shaw. Well, it depends. I think that you being aware of the case, any reporting on the case could yeet you from a jury, where somebody would say, hey, are you aware of this case? Yes, I've read every single motion or watched discussion of every single motion. Probably one of the parties is going to be like, you're too aware of this case, because you need to come in without formulating an opinion of it, generally unaware of it. And when you listen to these things, you will naturally form an opinion like, oh, I like this motion. Oh, I don't like this motion. Oh, this lawyer has annoyed me. Oh, that grammar is pissing me off. Like, oh, I'm tickled by this. Like, that's interesting. That's an interesting turn of phrase. So you start to make some judgments about things. So it depends on the attorneys, and it would depend on the questioning of the juror. Brandis Bedazzled, hello, thank you. 99-cent store has the best fall decor: wood, teal, grayish, natural pumpkins. Happy Tuesday, fam. Love from SoCal. Boo conservatorship. Thank you. Dr. Meow Practice, thank you for the super chat. Not sure if it works with StreamYard, but reader view on Safari removes ad from web pages for easier reading. Safari gives me sometimes the business when I use it with Google, but thank you. Because then I have to switch back and forth from Safari to Google. I have tried. I will try again. Sandy said, joking, do you think Gretchen Wieners will be suing over the use of the title Fetch for the rewards app I keep seeing ads for? I mean, she was the first, and now it's a thing. I think Gretchen Wieners should sue over the use of the word fetch. And if Gretchen Wieners doesn't sue, the writer of Mean Girls should sue, because she did try to make fetch happen and try to make fetch a thing. So Ashley Vincent, thank you for the catnip tip. Whitney, how do you know that Anna is basically living with, do you know that Anna is basically living with Josh? I mean, she shouldn't be. What happens when she gives birth? She can't stay with the newborn, right? I mean, she shouldn't be living with him. He should be separated from children and living at the people that agreed to live with him. So I don't know if she's basically living with him, but then who's with their kids? Because it was my thought that she was with the kids, but whatever. Sid B said they took pictures of hands because they have video or pictures of his hands at the keyboard of the computer or his phone. Not necessarily, but it could be. But if that's the case, they would need a search warrant for it because that would be trying to prove something. Literally made it back in time to hear you read my super chat. What? Welcome back. I know it's been a long stream. People are like, wait, what? How long is this stream? Long. They've been long since I've come back from vacation. Everybody's like, Emily's back from vacation and she won't shut up. Yes, there's a lot of motions. And I see it's either chop them down into a bunch of little streams and stream like all the time, or just take the time we have together and try to get through as much as possible, which is what I've been trying to do because I also have to prep the podcast for each week and Friday Night Live. So I'm going to take like 2 more and then I've got to bounce. It has been a busy day. We have a podcast episode coming tomorrow. We have Friday Night Live coming this week. If anything really pops off, there will be a text message if you're in the text crew, tweets, Instagram. That was loud. Instagram posts and YouTube shorts. Sometimes if I put them up, sometimes they get good views. Sometimes they don't. We put them up to get the information out quickly. Question regarding ScarJo and Bam, that was last week's episode of The Emily Show. Why do they create a hire out company rather than just signing the contract directly? This is a fantastic question, Karen, and I'm so happy to answer it because I actually know this. So with regard to hire out companies, it's for a few purposes. 1, liability purposes, 2, financial reasons, but 3, in California, the studios don't want to hire all the actors as employees because there's a lot of rules that regulate employees. And if you hire them directly, they are employees, even if it's just for the production of a movie, particularly with the way that contractors and employees are classified. So if they're hired through a hire out company, they are not employees of the studio. The hire out company hires them as employees and they have substantial tax benefits. They can own their own intellectual property. So financial reasons, tax reasons, carrying their own insurance and not being employees of the company. So, Ellie is saying Anna is with Josh, but the kids are with the grandparents. I mean, okay. I didn't know that. I don't think that's how I would choose to do that. I'm like, look, I know that you're being alleged to have done these things. I'll talk to you on the phone. I'm going to be with the kids, but that's just me. Sorry, B. I love you very much. But also during this kind of time, it seems like the kids would need a parent. That's just my personal opinion. Question request. Can we get a video on LLCs? Yes, I have podcast episodes that cover LLCs, but I think in light of everything going on with Erica Girardi, that's probably where the interest is coming from. So I can do a breakdown kind of in the context of Erica Girardi for sure. Yes, LLC info, please. Yes, absolutely. A stream dedicated to LLCs, pros and cons. I can absolutely do another creators. I'll probably do it as an upload because it'll be short, but I'll do another or do a creators stream and add a day to do kind of a creators business stream. I do a lot of that over on vidIQ's channel. I'm one of their creators that works with them. So on vidIQ's channel, we've covered some of this and we've covered like the business side. And I have a playlist on this channel called For Creators that has those videos too, where I talk about the business side of creating. So that will absolutely be there. Question, where's Rosengard's response to Dad Spears? Is he not going to do anything until 9/29? He doesn't have to do anything till next month. He has some time and I'm sure they are working on their response. I would not expect a quick response. And you've heard me criticize, like, if you have another week, why are we responding with this? So they're probably working on their response and we'll probably see it in September sometime. And 9/29 is going to be hard because I'm going to be traveling, but I will probably take what I need to take to stream so that I can, or I'll stream from my phone or my iPad. I can probably do that on StreamYard from my iPad, right? Can I? I hope so. I'll figure it out before I leave. Question, will you be covering Prop 22 in California being declared unconstitutional by a California judge? It's my understanding, well, I've not been keeping up with the California news nearly as well as I did, but it's my understanding that they declared one of the addendums unconstitutional. Prop 22 itself yes, it will be an Emily Show episode, but all the news that I've seen coming out about that is that the thing about the drivers was the problem. So I will definitely ask. Is Brittany really being sued by her housekeeper? Not that I've seen. It looks like there was a police report taken. I talked about that a bit on Friday. It seems like she got her dogs back, and that's exciting. All right, y'all. We are so close to 150. We're going to have to think of something to do to celebrate. Members, check your community tabs. I will be updating everyone on the move to Patreon. The law nerd member level will always be here. Members only live streams will be here, but we are also separating out a part to more exclusive content. And those of you that are here till the end, you always get the best information, and an exclusive podcast called I Have Thoughts, where I break down the thoughts behind the stories, like the whole thing, not just the stories, like assuming you've watched the stories, all of the thoughts on the stories and all of the ponderings and the ramblings. So we will be doing all of that. I appreciate all of you so much. Thank you for being a law nerd. Thank you for being here. I hope you have a wonderful rest of your Tuesday. Go get that pumpkin spice best life. I will be checking in with you on Instagram tomorrow with my pumpkin spice best life. And we will talk a little bit more about the added exclusive content coming to Patreon. I'm very excited about it. All right. Thanks for being a law nerd. Cheers. Have a great Tuesday. Bye.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.